All right, we are now streaming live. Please raise your right hand, everyone.
Por favor, todos levanten la mano derecha.
Do you swear or affirm that the information given to this court with the court-appointed forms or in person is the truth, the whole truth, and nothing but the truth? So help you. If so, say I do.
Ahora que a la corte los documentos que han entregado son la verdad, sino la verdad y la verdad.
Okay, please put your hands down.
Voy a bajar la mano ahora.
This is your first appearance before the Magistrate Court of Clayton County.
Es su primera aparición ante el magistrado de Clayton.
They're not here to try your case or take a plea.
No está para su declaración o hablar de su caso.
You're here for the court to inform you of your charges and to advise you of your rights.
Están aquí para que les expliquen sus casos. Que la corte les informe de que fueron acusados y sus derechos.
I may set bail for some of you,
Puedo poner fianza para algunos de ustedes.
and I may schedule a preliminary hearing for some of you.
Y voy a poner una audiencia preliminar para algunos de ustedes.
I will also determine whether you require the assistance of an attorney.
Can you repeat that for the interpreter, Your Honor?
I will also determine whether you require the assistance of an attorney.
También voy a determinar si requieren asistencia.
During this and all of the following hearings, you have the following rights.
Durante este siguientes tienen los siguientes derechos.
You have the right to remain silent and say nothing.
Tienen derecho a permanecer en silencio y no decir nada.
Should you give up this right, anything you say during this proceeding may be used against you if this case goes to trial.
Si desechan este derecho, todo esto puede ser usado contra ustedes si van a juicio.
You have the right to the presumption of innocence until the state proves your guilt beyond a reasonable doubt.
Tienen derecho a ser presuntamente inocentes, que se compruebe su culpabilidad de toda culpa, de toda duda.
Who is this person in the red shirt?
Your Honor, this is another person that needed a Spanish interpreter as well. He couldn't really
Right.
hear you from the back. Forward.
Right, who is he?
He's right here.
That is
Mr.
Tu nombre.
Jonathan.
Hold on, Emilio. I need to know who this person is so I can get his paperwork. Here's tu nombre.
Jonathan Aranda.
Jonathan Miranda.
Arada.
That's what he stated. That's what he stated.
Could you ask him to spell his name for me, please?
¿Puede letrar su nombre, por favor?
Jonathan Aranda.
Deletrear su nombre.
Jonathan.
First name Jonathan, Jonathan.
Last name?
Su apellido. ¿Cómo deletrea su apellido?
Aranda.
Aranda.
Okay, hold on one second. Mr. Aranja, I don't have you on my calendar.
Señor Aranda, no lo tengo en el calendario.
He's the first person on the calendar, Your Honor.
¿Cómo?
Arada.
Yes, ma'am.
Okay. You have the right to expedient public trial by jury.
Tiene derecho a un juicio público ante jurado.
You have the right to the indictment by grand jury for felonies or by accusation for misdemeanors.
Can you repeat that for the interpreter, please, Your Honor? I'm sorry.
Yes, you have the right to indictment by grand jury for felonies or accusation for misdemeanors.
Puede ser acusado por gran jurado o acusado por un crimen menor.
You have the right to see, hear, and cross-examine witnesses who are called to testify against you.
Tiene derecho a ver, escuchar y contraexaminar a los testigos que tengan contra usted.
You have the right to compel the attendance of your own witnesses by the use of a subpoena.
Puede traer a sus propios testigos usando una subpoena.
You have the right to testify in your own defense or offer evidence should you choose to do so.
Tiene derecho a testificar y presentar su propia evidencia si así lo gusta hacer.
But you do not have to, and no presumption of guilt is raised if you choose not to.
Your Honor, can you repeat that?
But you do not have to, and no presumption of guilt is raised should you choose not to.
No tiene que hacerlo y tampoco se va a ser considerado culpable si no lo hace.
You have the right to have an attorney represent you.
Tiene derecho a que un compañero lo represente.
I will appoint each of you an attorney, but you always have the right to hire your own counsel or to represent yourself.
Puede asignar un abogado, pero tiene derecho a contratar un abogado o a representarse usted mismo.
While I'm doing this, Deputy, could you check to see if Arada's already posted bond? Because they didn't send his paperwork over. So you just make sure nobody's bonding him out already.
Vaya acá, a los días, por favor.
The second man that was brought up.
No, no, ma'am, he did not.
You said he's not been bonded out?
No, ma'am.
Okay, could one of y'all ask the jail to send me over his paperwork? It wasn't sent over, and I'm thinking that's because they thought he was bonded out.
It's being sent over now, Judge.
Thank you so much.
Creo que no mandaron el papeleo porque creían que no había pagado la fianza.
Some of you will be allowed to post bond for your release from jail pending the prosecution of your case.
Algunos de ustedes les va a asignar una fianza mientras está pendiente para su caso.
This bond may be cash, commercial, or property.
Eso puede ser en efectivo, comercial o propiedad.
If somebody posts a cash bond, they will bring the entire amount of bond together with any fees to the sheriff's office.
Si alguien has asignado una fianza, tienen que pagar la fianza completa asociada con las cuotas de la oficina del sheriff.
The sheriff will hold the cash bond until your final court date, and once your final court date is had, the bond will be returned to whoever posted it.
En caso de que paguen fianza, el sheriff la va a guardar y cuando termine el caso se le regresa esta fianza.
Someone could also use a commercial bonding company who will take a percentage of the bond as a fee for their service.
También pueden usar una compañía de fianzas comercial que ellos solo cobrarían una parte del pago de la fianza.
That bond could be up to 15% of the total of your bond, and it will not be returned once your case is concluded.
Puede ser hasta 15% de la fianza original y ese dinero no se va a regresar cuando concluya el juicio.
Someone could also use a property bond as long as the property has equity at least 3 times the amount of your bond.
También puede dejar una propiedad siempre y cuando la equidad de la propiedad sea 3 veces dobles fianza.
Everyone will have special conditions on their bond.
Todos van a tener condiciones especiales para su fianza.
At minimum, you will be prohibited from violating any laws while out on bond.
Por lo menos van a estar prohibidos de romper cualquier otra ley mientras sigan bajo fianza.
Many of you will have additional conditions that keep you from going around certain people or certain places as a condition of your bond.
Algunos de ustedes van a recibir la instrucción de no acercarse a ciertas personas o ciertos lugares como condición de su fianza.
If anyone violates the bond conditions, your bond will be revoked and you will not be entitled to a new bond while awaiting trial.
Si alguien viola las condiciones de su fianza, Your Honor, would you be so kind to repeat that for the interpreter?
If anyone violates their bond, the bond will be revoked and will not be entitled to a new bond while awaiting trial.
Si alguien viola las condiciones de su fianza, otorgar una fianza nuevamente ante su juicio.
Additional charges may be brought against you where you face up to 10 years in prison or $20,000 in fines and fees.
Hay cargos que pueden llegar hasta los 10 años.
If you have friends or family members who are assisting you with posting bond, they should wait at least 3 hours from the conclusion of the calendar before attempting to post your bond.
Si algún amigo o familiar los va a ayudar a pagar la multa, tienen que esperar por lo menos 3 horas desde que termine esto para poder pagar la fianza.
If a friend or family member is deemed to be the alleged victim, he or she will not be allowed to post your bond.
Si este miembro de la familia de la supuesta víctima, no se le va a permitir pagar su fianza.
For some of you, you are facing charges which the court is not authorized to set a bond.
Algunos de ustedes tienen cargos que la corte no está autorizada para dar su fianza.
The court also has discretion as to whether or not they wish to set a bond.
Nos reservamos la confianza de poner o no poner la fianza.
Also, if you are currently on active probation, the court is not authorized to set a bond.
Si está bajo probación, la corte no está autorizada a poner una fianza.
If you are on probation, your probation officer will determine, usually at your preliminary hearing, whether or not to consent to a bond.
Si está bajo fianza, si está bajo probación, su oficial de probación es el que va a decir si se les pone una fianza.
The purpose of a preliminary hearing is to determine whether or not there is enough probable cause to keep you detained while your case is being prosecuted.
La audiencia preliminar es para ver si hay causa probable suficiente para mantenerlos aquí mientras se persigue su caso.
If you are charged with misdemeanors only, you have the option of waiving your preliminary hearing, which will move your case a little bit faster through the court system.
Si son cargados de acusados de un delito menor, pueden ser echados su primera audiencia y esto va a hacer que su caso proceda más rápido después.
If you waive your preliminary hearing, you are not waiving any of the rights I spoke of earlier. You are merely moving your court case from magistrate court directly to state court.
Si deciden desechar su aparición inicial, no desechan ninguno de los derechos, solo cambia su corte a corte de circuito.
If you post bond, your preliminary hearing is automatically waived. Please keep this in mind.
Si pagan fianza, su audiencia preliminar es desechada. Tengan esto en mente.
We will take Mr. Arada and Mr. Rivera first. We will follow them with the female inmates, and we will conclude with the male inmates. And I guess that will be the last of the first appearances, and then we will follow that with our extradition hearing.
Primero vamos a tener a la señorita, después el caballero, y después seguimos con la audiencia de extradición.
Mr. Arada, you are charged with following too close and no license.
Señor Lado está siendo acusado por seguir muy de cerca y no tener una licencia válida.
Do you understand your charges?
Entiendo sus cargos.
Sí.
Your bond on following too closely, he said, see, your bond on following too closely is $500.
Seguir muy de cerca es de $500.
Your bond for no license is $1,500.
Su fianza por no licencia es de $500.
For a total of $2,000.
Total de $2,000.
You shall not violate any laws out on bond.
No pueden violar estas condiciones mientras está bajo fianza.
Are you able to make bond?
Puede pagar su fianza.
Sí.
Your next court date is going to be September 13th at 8:30 a.m.
13 de septiembre a las 8:30 de la mañana. Su próxima fecha de los próximos.
Have a good day.
Que tenga buen día.
Mr. Rivera,
Sí, señor Rivera.
Sí.
you are facing
Yes.
improper lane change and DUI charges.
Está siendo acusado de cambio inapropiado de carril y manejar bajo la influencia.
Do you understand your charges?
Entiendo sus cargos.
Sí.
For the improper lane change, your bond is $500. And for the DUI, your bond is $5,000 for a total of $5,500.
Cambio inapropiado de carril son $500 por manejar bajo el estado, son $5,000 y fianza total de $5,500.
You must not violate any laws out on bond.
No puedo violar ninguna ley de la fianza.
Are you able to make bond?
Puede pagar fianza.
Sí.
Your next court date will be September 13th at 8:30 a.m. Have a good day.
Septiembre 13, 8:30 de la mañana. Su próxima fecha de corte.
All right. Thank you so much, Emilio. You have a good day, okay?
Thank you for using our services, Your Honor. I hope you can satisfy anything else I can say.
No, thank you so much. Have a good day. Thank you. Bye-bye. I was able to do Mr. Arata's first appearance because of his bond sheet, but I still do need his warrant so they can send them over for me. But we can keep going, y'all. Thank you for y'all's patience. Let's go ahead and start with the females.
Who we got? All right, Mr. Barker.
Patricia Barker.
Okay, Judge.
Thank you.
Side of the wall.
Good morning.
Good morning, ma'am. Give me 1 second, Ms. Barker.
You got him? Yeah. Awesome. Thanks so much. Yeah, that's another thing. Send them all out, man. Yeah, she hadn't even done those yet, so. We got it.
All right, Ms. Barker, I apologize for the delay. You are charged with possession of marijuana less than an ounce and speeding. Do you understand your charges?
Yes, ma'am.
Your bond on the possession of marijuana is $1,500 and your bond on the speeding is $1,500 for a total of $3,000, and you shall not violate any laws on a bond. Are you able to make bond?
I'm sorry, it's kind of hard to hear you. I'm sorry, can you please repeat that?
Give me 1 second. I'm gonna turn my microphone up because I gotta make sure this is nothing on my
No, it's-
end.
It was us, Judge. It was just up too loud that it was echoing, so I mean static. But we can hear you now.
Okay, thank you. I'll start over. Ms. Barker, you are charged with possession of marijuana less than an ounce and speeding. Do you understand your charges?
Yes, ma'am.
For the possession of marijuana, your bond is $1,500. For the speeding, your bond is $1,500 for a total of $3,000, and you shall not violate any laws without a bond. Are you able to make bond?
Yes.
These are misdemeanor offenses, which means you have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing?
I'm sorry, can you explain to me what that is again?
No, ma'am, I thoroughly explained it. You don't understand, which is fine. Your next court date will be September 13th at 8:30 a.m. in room 201. Have a good day.
Okay, you said December 31st. Okay.
September 13th, ma'am. Y'all listen. Barbie English is next.
Okay. You good, you good, you good.
Ms. English, good morning.
Good morning.
You are charged with battery. Do you understand your charge?
Yes.
Your bond is $3,500. A condition of your bond is that you should stay away from Jericho Ford. You shall not return to 6668 BA A9 in Mount Zion. It was indicated that that's your residence. As such, I will allow you to go with the sheriff's escort for the limited purpose of retrieving your personal property. However, you may not go back to that property without an escort until this case is resolved or until that condition is modified by another judge. You must also not violate any laws without on bond. Do you understand, ma'am?
Yes, ma'am.
Are you able to make bond?
Yes.
Ms. Barbie, this is a misdemeanor, which means you have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing?
Yes.
Thank you. Please sign your waiver, leave it with the deputy, and they will send you your next court date in the mail, okay?
Okay, thank you.
Have a good day. You're welcome. Next is Twanisha English.
What's your name right here? It sounds like it's print.
Ms. English, you were charged with terroristic acts, which is a felony. Do you understand your charge? Your bond is $10,000. You should have no contact with your.
Sorry. Let's repeat it one more time. I'm sorry.
I'm going to start over. You are charged with terroristic threats and acts, which is a felony. Your bond, you said you understood your charge, correct?
Yes, ma'am. I heard.
Bond is $10,000. You're to stay away from Jericho Ford. You shall not return to 6668 BA A9 in Mount Zion Boulevard, and you must not violate any laws out on bond. Are you able to make bond?
Yes, ma'am.
Your next court date is September 14th at 8:30 a.m. Have a good day.
Thank you.
Thank you.
No, she didn't wait.
She has a felony. I don't allow people to waive their felonies, so she can move on. You, Ms. Gray? I recognize you from yesterday, but your name was on my calendar, but they did not send your paperwork over. It looks like
I
you
was
were,
confused. Again,
ma'am,
I was confused on why I was coming back again as well.
the charge that I have in front of me is the failure to have your headlights on. I'm not sure if that was something that you were brought before me yesterday for, but the bond is $500. All the other conditions I put in place yesterday are still in place. Do you wish to, I'm not gonna allow you to waive this one because you already have court with the other ones. So I'm gonna put this down for the 14th with your other charges from yesterday, okay?
So I go on the 12th and the 14th now?
Excuse me, the 12th. Thank you for reminding me. So no, you'll go on the 12th for all of your charges. I'll make sure I add you to the 12th calendar with this one. Have a good day. Deputy, could you have them send over Ms. Gray's new paperwork because I didn't receive any paperwork for her as well?
Yes, ma'am.
Thank you so much. If you need me to send an email, I can, but I know y'all probably have a quicker way of communicating with them. I did not receive her paperwork for today's calendar.
She'll be last.
Are you Ms. Jackson, Lachey Jackson?
Yes, ma'am, I am.
Give me one moment. All right, we're back on the record. Ms. Jackson, you were charged with simple battery, family violence, and theft by taking. Do you understand your charges?
Yes.
The theft by taking is a felony charge. So for the battery, family violence, simple battery, family violence, your bond is $5,000. For the theft by taking, your bond is $10,000 for a total of $15,000. A condition of your bond is that you shall stay away from Shante Stevens. You shall not return to 7124 South Lake Parkway in Morrow. It was indicated on the documents that this is your shared residence with Ms. Stevens. As such, I will allow you to return to that property for the limited purpose of retrieving your personal property, but you have to go with the sheriff's escort if you do go back for that purpose. However, you're not allowed to go back to that property for any reason without a sheriff's escort until this case is changed or until that condition is modified by a different judge. You must also not violate any laws while out on bond. Do you understand all of those conditions?
Yes, ma'am.
Are you able to make bond?
Yes, ma'am.
Your next court date will be September 14th at 8:30 a.m. in room 201. Have a good day.
Thank you.
You're welcome. Are you Ms. Kemp?
Yes, ma'am.
Ma'am, you are charged with battery. Do you understand your charge?
Yes.
You were hesitant. I'll ask you again. You are charged with battery. Do you understand your charge?
No, ma'am.
It is alleged that you committed offensive battery when you intentionally caused substantial physical harm and visible bodily injury to Anaya Vice by striking her several times in her head and upper body areas with your closed fist. The bond is $3,500. You shall stay away from Anaya Vice or Anaya Vice. What's your relationship to Ms. Vice?
No relation.
Okay, so there should be no reason for you to have any contact, correct? You must also not violate any laws while out on bond. Are you able to make bond?
Yes, ma'am.
This is a misdemeanor, which means you have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing?
What does that mean?
I've already said that, ma'am. You don't understand, that's fine, but I'm gonna go ahead out of an abundance of caution and set you down for September 13th at 8:30 a.m. in room 201. Have a good day, ma'am.
Thank
this
you.
way,
You
ma'am.
as well.
You're welcome. Thank you. Salama Kuyate, forgive me if I misspelled your name, mispronounced your name. How do you say your name, ma'am?
Salame Kuyate.
Kuyate,
Yes, ma'am.
you are charged with battery and criminal trespass. Do you understand your charges?
Yes, ma'am.
Your bond on the battery is $3,500 and the bond on the criminal trespass is $3,500 for a total of $7,000. A condition of your bond is that you must stay away from Haja Kuyate. You shall not return to 6090 Camden Forest Drive. It was indicated that that is a shared residence. As such, I will allow you to go with a sheriff's escort for the limited purpose of retrieving your personal property. However, you may not go back to that property without a sheriff's escort until this case is resolved and that matter is modified, that condition is modified by another judge. Do you understand, ma'am? Do you understand, ma'am? You must also not violate any laws without on bond. Are you able to make bond?
Yes.
These are misdemeanor offenses, which means you have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing?
Yes.
Thank you, ma'am. Please sign your waiver, leave it with the deputy. Your next court date will come in the mail. You are going to change your address with the court because you can't go back to this address. So just make sure that they are updated with your address, okay?
Okay, thank you so
Have
much.
a good day.
Okay, next.
Go ahead.
Go ahead, ma'am.
Go ahead. Sign the description right here.
Are you Miss Lester?
Yes, ma'am.
Are you leaning on that wall? You have an issue? Okay, looks like you were leaning. Okay, we still in court, okay? Ma'am, you're charged with criminal trespass. Do you understand your charge? Your bond is $3,500. A condition of your bond is that you shall stay away from Ashika Lester. You shall not return to 4007 Poplar Point. It was indicated that that's the shared residence. As such, you can go back with the sheriff's escort for the limited purpose of retrieving your personal property. However, you cannot go back to that property without a sheriff's escort until this case is resolved or until that condition is modified by another judge. You must also not violate any laws out on bond. Do you understand?
Yes, ma'am, but she no longer stays at the residence. It's no longer a shared residence.
It was indicated on the warrant that is the shared residence. I have appointed an attorney to represent you. Your lawyer can look into that a little bit deeper, and if that condition needs to be modified, where that's no longer an issue, where you're not going over there, that's fine. But for right now, based on the information I have, it is indicated as a shared residence. As such, you are not allowed to go there unless you go with the sheriff's escort for the limited purpose of retrieving your personal property. Do you understand, ma'am?
Yes, ma'am.
Are you able to make bond?
Yes, ma'am.
What was that? I'm sorry.
Yes, ma'am.
Okay, I looked down, so I didn't hear you. This is a misdemeanor offense. You have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing?
What does that mean?
I'm going to set you down for a preliminary hearing to be held on, and I'm not, I explained it earlier, so if you didn't understand it, I understand, but I'm just going to sit you down for one on the 13th out of an abundance of caution. You do have an attorney. You all may decide at a later date to waive it, or if you bond out, as I stated earlier, it will be automatically waived. But for now, it's going to be the 13th at 8:30 a.m. Have a good day, okay, ma'am? Are you Ms. Snow?
Yes, ma'am.
Good morning. Give me one moment.
No problem.
Ms. Snow, you were charged with simple battery. Do you understand your charge?
Yes, ma'am.
Your bond is $3,500, and you shall stay away from Jamari Richardson. You shall not violate any laws while out on bond. Do you understand?
Yes, ma'am.
Are you able to make bond?
Yes, ma'am.
This is a misdemeanor offense, which means you have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing?
Yes, ma'am.
Thank you. Please sign your waiver and leave it with the deputy. Your next court date will come in the mail. Have a good day, ma'am.
You too.
Thank you. Ariel Taylor.
How you doing, Judge? Ariel Taylor, we're gonna do her last, okay? Last after the last, yeah, Woody.
Aaron, excuse me.
Miss Thomas is right here.
LaTanya Thomas.
Yes, ma'am.
Give me one moment.
Sure.
Ma'am, you were charged with a felony count on the violation of the Georgia Controlled Substances Act. Do you understand your charge?
Yes, ma'am.
Your bond is $8,000, and you shall not violate any laws while out on bond. Are you able to make bond?
Yes, ma'am.
Your next court date will be September 14th at 8:30 a.m. in room 201. Have a good day.
Thank you.
You're welcome.
We got to get that. We got to get the email first.
Are you a native Vice?
Yes, ma'am.
Ms. Vice, you were charged with a fray. Do you understand your charge? Your bond is $1,000. You should stay away from Ariel Walker. Do you have any relationship with Ms. Walker? Okay, so you should have no contact with Ms. Walker, and you should not violate any laws out on bond. Are you able to make bond? This is a misdemeanor offense, which means you have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing? I didn't hear you. I looked down. I'm sorry.
Yes, ma'am.
Please sign your waiver, leave it with the deputy. Your next court date will come in the mail. Have a good day. Ms. Walker, how old are you?
I'm good.
How old are you?
17.
You were charged with a fray. Do you understand your charge?
Yes, ma'am.
Your bond is $1,000. You shall stay away from Anaya Vice, and you should not violate any laws out on bond. Are you able to make bond?
No.
Do you understand your charge, your conditions of your bond?
Yes, ma'am.
This is a misdemeanor offense, which means you have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing? Please sign your waiver, leave it with the deputy. Your next court date will come in the mail. Have a good day.
Thank you.
Is that all of the female inmates you have?
No, ma'am, you got Miss Woody coming up.
Okay, I thought Woody was a male. Give me 1 second. No, I didn't. It's not because of how you look, Miss Woody. Don't do that. Don't do that. You look good. No, we're not doing that. Your nails look good. I only thought you were male because of what I was looking at on my paperwork, not because I was looking at you. So please forgive me.
Okay, last name.
No, you're looking good. You're looking good. Please forgive me. That's my bad.
Thank you, Your Honor.
Ma'am, you're charged with a felony count of violation of the Georgia Controlled Substances Act, and you're charged with use or possession of drug-related objects. Do you understand your charges?
Yes, ma'am.
For the drug charge, your bond is $10,000. For the possession of a drug-related object, the bond is $1,500 for a total of $11,500. You shall not violate the laws out on bond. Are you able to make bond, ma'am?
Most likely, yes, ma'am.
Okay, your next court date will be September 14th at 8:30 a.m. in room 201. Have a good day.
It's September 11th, if I make.
September 14th. Have a good day.
All right, Judge, we have Miss Taylor coming up last.
Okay.
Follow his instructions.
Come over here, make sure your hand behind your back. Come on. Stay right here on this wall.
Ms. Taylor, you're charged with criminal trespass. Do you understand your charge?
Yes, ma'am.
Your bond is $3,500. Condition of your bond that you shall not return a day's in Stockbridge, and you must not violate any laws while out on bond. Are you able to make bond?
Yes.
Your next court date is going to be September 13th at 8 a.m. Excuse me, 8:30 a.m. in room 201. Have a good day.
All right, so we ready to go? Yes, sir. Okay.
Give me 1 second.
Can I get the hand sanitizer, please?
So. Intake.
Right here.
I'm about to tell you what you got. Come on, let's go, man. Come on. We'll talk, man. Come on. We'll talk, man. Yeah, we'll talk. Parents over.
Bring your nails up.
Put it on, me.
All right, let's continue on. We're ready for the male inmates. Are you all ready? You all having an issue at the jail? I see some.
Good morning, Judge. Yeah, we're getting the mails now. We had to separate them all down to the other end.
No worries. I'll be ready when you are.
What?
Run Brown.
Okay,
Orlando
Judge, we're ready.
Brown.
Just for the record, I still have not received paperwork for Mr. Arata or Ms. Gray. I'm not sure if they already bonded out, but if y'all could send that over, I would greatly appreciate it. Sir, what's your name?
First name is Hanny, last name is Barohan.
Give me 1 second.
Yes, ma'am.
I also don't have paperwork for Mr. Barohan. I'm not sure. Did somebody bond him out as well? He has charges that already had bonds assigned to him.
Judge, is there any way I could get an OR?
Unfortunately, our chief judge, Keisha Wright Hill, does not, I won't say unfortunately, she does not allow OR bonds. Your bonds that are preset for your charges is 500 on the passing, 500 on the improper lane, and 1,500 on the possession of marijuana, for a total of $2,500, but there are no OR bonds for our chief judge.
I mean, is there anything you could help out? Like, I got a family to take care of. Like, these are petty, really petty. Like, they're traffic citations, and she escalated the situation by saying that she smelled marijuana odor coming out the vehicle, and she found crumbs inside of my glove department. And that's the only reason why I'm here, for some crumbs. Like,
I'm gonna stop you because the way it works is I just have to read the charges and the bond amount. I can't really go into the defenses, and it sounds like you're trying to give me the defense, which I totally understand, but it's not appropriate because there's no prosecutor here and there's no defense attorney here. So you may inadvertently end up saying something that may get you in more trouble. So I have appointed an attorney to represent you. I do not have any authority to give you an OR bond, and your bonds are preset. Somebody may have already posted it because they did not even already send over your paperwork. Did y'all check on that for me, for Mr. Burringham?
Oh, somebody's already on it?
We're checking, sir, because I didn't see your paperwork.
Thank you, Judge. I appreciate that. Thank you.
You know, all those, everybody else was sent in a separate email. So Mr. Arada and Ms. Gray, they was all sent as well. They were sent earlier.
Okay, I didn't receive that email.
So you didn't receive it?
No. I did not. If they can forward it again, I will be happy to look at that paperwork. But sir, as I stated, your bond is $500 on the passing, $500 on the improper lane change, and possession of marijuana, $1,500. Now you can talk to your lawyer about whether or not they could see if they could petition another judge for a lower bond, but I am not authorized to give you an OR. Okay.
Okay. Did you check on the to see if they already
The jail has to check on that. I have no way to check that, sir. The jail has to check on that. So I'm gonna let you go because we're slowing things down. But your next court date will be September 13th at 8:30 a.m. Have a good day, sir.
Yes, ma'am.
Did you all bring over Mr. Edwards from yesterday? Are you Mr. Edwards?
No, Mr. Brown, Michael Brown.
Give me one
Mr.
second.
Edwards?
Yes. Did you all know about Mr. Edwards from yesterday? He was reset due to conduct.
He's on the way, Your Honor.
Okay, they got him coming, Judge.
So we'll put him at the end.
Yes, ma'am, that'd be good.
Okay. And I'm sorry, sir. What was your name? Mr. Brown?
Michael Brown.
Okay, give me 1 second, sir. Sir, you are charged with battery, family violence. Do you understand your charge?
Yeah, we got a little tussle, we felt.
Okay, again, I don't want you to say anything that may potentially incriminate you. I just asked you, do you understand your charge? So I'm not saying you're guilty or innocent. That's not what this court that is for. I'm merely here to read your charge, which is that you are charged with battery, family violence. Do you understand it, sir?
Yes.
Okay, and I'm not being ugly. Like I said, I just don't want you to say something that may inadvertently affect your lawyer's ability to represent you. So again, you do understand your charge. Your bond is $3,500. A condition of your bond is that you shall stay away from Shatia London and Deja Boaz. You shall not return to 9114 Highway 54 in Jonesboro, and you must not violate any laws out on bond. Do you understand those special conditions?
I'm from out of state, Your Honor, and I got a flight Monday afternoon. How do I go about all this?
How do you go about what, sir? My question was, do you understand your special conditions?
I understand them, man.
Okay, so what are you asking me?
I'm asking you, how can I fly out Monday afternoon. Any type of way I can get released and come back, or you know.
I gave you a bond. What are you? I'm confused. Are you tracking?
The bond, I can't afford the bond. I can't pay for the bond. I'm from out of town, I'm out of state.
Oh, okay. So like I said earlier, I don't have the authority to do anything other than a bond. I can't give you an OR or a signature bond. Our chief does not allow us to do signature bonds. So I have to set a bond, and your bond that I've set is in line with the review of the case and your history. So the $3,500 is the lowest I can go. There is no contact with the alleged victim, and you must not violate any laws without a bond.
Man, I got a job. My job gonna be lost. Everything gonna be lost. I got a flight Monday afternoon. I'm from Jersey, and so I'm about to.
You got a flight tomorrow. What time is your flight?
My flight's like 4 o'clock, 4:30.
What airline are you flying on?
I'm flying on, the yellow,
Hey.
Oh, damn.
What time and what airline?
It's, oh, the yellow, what's the yellow airplane? What's that yellow?
Spirit?
Spirit, yes, ma'am.
Where are you flying to?
Flying to Atlantic City, Atlantic County.
You have a flight tomorrow. What time on Spirit Airlines?
Yes, 4:30, about 4:30, 4:00, 4:30.
Okay, you can go back. I'm gonna look into this. Give me one moment.
I appreciate it, guys.
Judge, you want us to keep him?
Yes, please. Taiwan Bush.
Get your name, step up.
Hey, how you doing, Judge?
I'm well. How are you? Mr. Bush, you are charged with battery, family violence, and criminal trespass. Do you understand your charges?
Yeah.
Mr. Bush, you pled NOLO to a similar charge on November 19th of 2015. As such, battery, family violence is now considered a felony in the state of Georgia because of your previous NOLO to that charge. Your bond on the criminal trespass is $1,000. Your bond on the battery, because of the felony, is $7,000, for a total of $8,000 bond. Condition of your bond is that you shall not have any contact with Karen Cruz. You shall not return to 5030 Old Dixie Road, apartment 71. And it is indicated that is a shared residence. As such, you may go back with the sheriff's escort for the limited purpose of retrieving your personal property. However, you may not go back to that property until this case is resolved or until that condition is modified by another judge. You must also not violate any laws while out on bond. Do you understand, sir?
Yes, ma'am, but ma'am, the situation is we had to move out this apartment Monday. We had to move out Monday, and I can't get my stuff, and my car is parked there. I got all my stuff inside of the apartment, and she also have all her stuff inside of the apartment. We supposed to be moving Monday.
Okay, so I'll give you a bond. If you post bond, if you go to the sheriff's escort, you can get your personal property out of that place.
I don't have that type of money, man. And I have my job and all that is on the line. I was just getting home from work when all this occurred. The only thing I did was they said I broke their cell phone.
Again, I don't want you to go into what happened. I'm not sure if they can they hear what's going on ahead of them, because I'm doing a lot of repeating myself. So if you couldn't hear what's going on, I do apologize, but this is not the place for you to tell me what happened. It's not appropriate because, number one, we don't have the state here and you don't have your lawyer here. So you may inadvertently say something that implicates you or makes you, so I'm not going to hear that. I'm not trying to cut you off, but I'm trying to protect your rights and your interests. Okay. My only question was, are you able to make bond? I hear you saying no. Okay, I have an attorney to represent you, and they will talk to you about how to get this matter moving forward. But I'm not going to be able to modify this at this time because it is a felony. Your next court date is going to be September 14th at 8:30 a.m. in room 201. Have a good day.
All right, go CS1.
Antoine Evans.
Yes, ma'am. Good morning.
Good morning. Give me 1 second.
All right.
Stand in front of CS1, sir. Put your hands on your back, bro.
There's some bullshit. There's some bullshit, bro.
People using profanity is very disrespectful to the court, because I promise you, if we were meeting in person, you would not be doing that, or you'll be held to contempt. So whatever you feel, keep it to yourself. Now, I've been very respectful, but very serious, and you all real respect the court.
Everybody know where they came from, like what house and then. Once you finish, you're going back to your house. You're walking by yourself. Oh, you did?
All right, Mr. Evans.
Yes, ma'am.
I apologize for that. I know that wasn't you saying that, but I did hear. You were charged with simple assault, criminal damage in the second degree. Well, 2 charges of criminal damage of property in the second degree, and 2 charges for simple assault. Do you understand your charges?
Yes.
For each count, your bond is $5,000 for a total of $20,000. You shall stay away from Ms. Patel. You shall not return to the American Inn and Suites on Mount Dixie, and you shall not violate any laws or out on bond. Do you understand, sir?
Yes.
Are you able to make bond?
No, ma'am.
Your next court date is September 14th at 8:30 a.m. in room 201. Have a good day.
All right, thanks.
You're welcome. Jordan Galowski. Y'all excuse me, I'm feeling a little country today. Drink some water. Galowski.
He might be in, I have one in.
Your Honor,
Yes.
we have a Ramondo Brown that didn't go yet.
My understanding is Mr. Brown is a alleged fugitive.
Is he a fugitive?
I didn't get the piece of paperwork.
Oh, man, go sit down. Just, call, intake, see if they got
We have Jordan Galowski.
Gonna need some help, yeah. Yeah, you just call intake, see if they got the paperwork. If you're the normal comes in, right before. Yeah, you're gonna need some help standing by.
Yes, sir. Are you Mr. Galowski? Sir, you are charged with battery. Do you understand your charge?
Yes, I do, ma'am.
Do we, what's your name?
Jordan Galowski.
Mr. Galowski, do you understand your charge with battery?
Yes, ma'am.
You are charged with battering Lavert Robinson. What's your relationship to Mr. Robertson?
He's my caregiver.
He's your caregiver. Do you live with him?
No.
Okay. So Mr. I'm gonna make your bond $1,000. You can have no contact with Mr. Robinson, okay? Your next court date is gonna be September 13th at 8:30 a.m. Okay? Will y'all make sure y'all write down that court date for him, please?
Yes, ma'am.
Thank you. And I'm gonna make a note for your lawyer to come see you, okay? All right, have a good day.
Where did you come from? Y'all know? Where did you come from? Y'all know?
Marcus Jackson.
They don't have it. That's it. Come on, Jim. Let's ride. Come on. I got you. You got it? Yeah. I'm in. Come on, right?
Mr. Jackson, you were charged with DUI, open container, and improper lane change. Do you understand your charges?
Yes, ma'am.
On the DUI, your bond is $10,000. On the open container, your bond is $500. And on the improper lane change, your bond is $500 for a total of $11,000. You shall not violate any laws on bond. Are you able to make bond?
Yes, ma'am.
These are misdemeanor offenses, which means you have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing?
No.
Your next court
I'm not sure what that means. I'll just wait to talk to my attorney.
Okay, sir, that makes sense. Your next court date is September 13th at 8:30 a.m. in room 201. Have a good day.
You too.
Thank you. Christopher Jefferson.
Grand Rising, Judge.
Grand Rising. Give me one moment.
No worries.
So you're charged with aggravated assault, disorderly conduct, and possession of marijuana less than an ounce. Do you understand your charges?
No, ma'am.
It is alleged that you committed the offense of aggravated assault when you made threats to the victim, T. Watkins, stating that she was about to go to heaven and that you were going to meet her there. That you then pulled out a Springfield Hellcat 9mm firearm, black in color, after the threat. That you were violent and acting in a tumultuous manner when you were screaming and throwing items at the Quick Trip. That you also had a jar with a green leafy substance suspected of marijuana. That all these incidents occurred in Clayton County, Georgia. You do not have a bond on the aggravated assault. On the disorderly conduct, your bond is $1,500, and on the possession of marijuana, your bond is $1,500. But as I stated, you do not have a bond on the aggravated assault charge. Should you get a bond, a condition of your bond will be that you should stay away from T. Watkins and not be around her in any way. Your next court date will be September 14th at 8 a.m. in room 201. Have a good day.
Yes, ma'am.
Thank you. You all give me 1 second. I need to check something.
Yes, Your Honor.
It's okay. Can you go back and ask her? Because I'm not being charged with felony or anything, even criminal trespassing. She said that she's not figuring out.
Will you bring back Mr. Brown?
Back, Mr. Brown?
Mr. Brown?
Yeah, Michael Brown, who has the flight tomorrow. Mr. Brown, I'm gonna keep everything in place. I didn't see anything to verify travel on that airline. There are no flights tomorrow anywhere in the vicinity of that time. If you have family members, let me finish, that want to bring a copy of your verified travel to the jail, then I can put that as a condition. With verified travel, I will reduce your bond from $3,500 to $1,500 with confirmed travel for a flight tomorrow. I don't see any flights that go out at 4:30 tomorrow, sir. I'm not saying you're lying. I'm just saying I don't see it as such. Your bond shall remain as it is, which is $3,500. You shall have no contact with Ms. Longden or Ms. Boaz. You shall not return to 9114 Highway 54. You must not violate laws out on bond. Your next court date will be September 13th at 8:30 a.m. in room 201. As I stated, I will write down if you have, stop with the drama. Stop it. Stop it. Stop it. You told me you have a flight confirmed. If that's the case, whoever has the ticket can bring it up here to the jail and show them that you have a flight confirmed for tomorrow at 4 whatever. I don't see any flights in Spirit anywhere from 4, 4:15, 4:30, 4:45. So I don't know what you got going on, but we're not doing the drama. If you have it, it's fine and it'll be covered. If you don't, the bond is what it is. Have a good day.
So who I'd bring?
Have a good day.
Who would I bring papers to?
James Kenner.
Good morning, Your
Good
Honor.
afternoon, sir. How are you?
I apologize. I'm great.
Sir, you're charged with theft by conversion, no license violation, and possession of marijuana less than an ounce. Do you understand your charges? For the theft by conversion, your bond is $10,000. For the license, your bond is $1,000. For the possession of marijuana, your bond is $1,500 for a total of $12,500, and you shall not violate any laws out on bond. Are you able to make bond?
I'll probably make it by Wednesday, Thursday.
Okay.
I need to call my family. I haven't talked to my family yet.
Okay.
So that's altogether is 12,000, you said?
12,500, yes, sir.
1250.
Your next court date will be September 14th at 8:30 a.m. Have a good day, sir. Damian Major. Are you Mr. Major?
Good afternoon. Yes, ma'am.
Good afternoon. You are charged with battery and criminal damage to property in the second degree. Do you understand your charges?
Yes, ma'am.
All right. On the battery charge, your bond is $3,500. On the criminal damage to property, it is a felony, and that bond is $7,000 for a total of $10,500. You should have no contact with Treshonda Smith. You shall not return to 870 Madison Court. Although it was indicated that that is a shared residence, you may be allowed to go with a sheriff's escort for the limited purpose of retrieving your personal property. However, you cannot go back to that property for any reason until this case is closed or until that condition is modified by another judge. You must not violate any laws while out on bond. Do you understand?
Yes, ma'am. Could you tell me what my bond amount was again?
Yes, sir, 10,500.
Okay,
Are you able to make bond?
yes, ma'am. I just have to call my family.
Okay, your next court date will be September 14th at 8:30 a.m. Have a good day, sir.
You do the same. Thank you.
Thank you. You're welcome. Devon Milliner. Mr. Milner, you're charged with a license violation and no tail lights. Do you understand your charges, sir? On the license, your bond is $1,000. On the tail light, your bond is $500 for a total of $1,500. Are you able to make bond? A condition of your bond is that you must not violate any laws while out on bond. These are misdemeanor offenses, which means you have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing? That's a yes, sir.
Yes, sir.
Thank you. Please sign your waiver, leave it with the deputy. Your next court date will come in the mail. Have a good day.
Give me your name so you tell you where you go.
Mr. Wynn is still in medical, correct?
What was that, Judge?
Mr. Wynn is still in medical? That's the one we talked about earlier. Is he still in medical?
Isolation. Yes, ma'am.
Yes, ma'am.
Medical isolation. So we're gonna reset him for tomorrow to find a way to do that safely.
Okay,
All right.
Judge.
So we've already done, no, excuse me, Mr. Richardson should be next, Jamari Richardson.
Hey, good morning.
Come on, Mr. Richardson, give me one moment.
Can I say Rich?
All right, Mr. Richardson. You are charged with criminal damage to property in the second degree. Do you understand your charges?
Yes. Yes.
Why are you playing with your hair? What's going on?
Nothing, my bad.
Okay. It don't look bad. It just is what it is. But I need you to focus with me. You're distracting me. Pulling it up, pulling it down. So again, you understand your charges? Okay. So a condition of your bond is going to be $20,000. A condition of your bond is that you should stay away from Alonzo. What's his last name?
Bird.
That's what I thought. I couldn't quite recognize it. You should stay away. You should stay away from Mr. Bird. You should not return to 10199 Fox Fire Terrace. You should not violate any laws while out on bond. Are you able to make bond?
What it is again?
$20,000.
$20,000.
Yes.
You can't tell me half of that? Oh, I gotta figure that myself.
You can always use a bonding company. I reviewed the charges as well as your criminal history, and that's why I arrived at that bond. I have to make sure I set a bond in line with the charges as well as the history to determine whether or not you will be a threat to the public or whether you will reoffend. So that's why your bond is what it is. So again, I'll ask my question, whether you use a bonding company, cash, or commercial property, any of that, are you able to make bonds, sir?
Probably, I don't know.
Your next court date is going to be September 14th at 8:30 a.m. Have a good day, sir.
Back to House Meeting 7. So I'll be down home the right hand side.
I'm showing that Alonzo Payton is no longer in. Are y'all having him? Y'all still have him?
He's right
Come on,
here.
sir.
Alonzo Payton is still there?
Yeah, I'm right here in front of you.
I don't have his paperwork. I'm trying to see what's going on. There's still several people who's missing paperwork. And that email that y'all said was sent, it never was resent with those people that we spoke about earlier. I'm sorry, Mr. Payton. Step back. We need to get your paperwork, okay?
We're double checking for the paperwork now, Your Honor. If we have it,
Thank
we'll
you.
send it over.
Hey, this Ms. Lewis, it is definitely gone. Do we have any?
James Smith. His paperwork wasn't sent over either. Mr. Smith, your paperwork wasn't sent over either. Are you Mr. Smith? Your paperwork was not sent over either. So I'm gonna have you sit back and we're gonna go through it, okay? So if you say,
Stand over there for me.
Oh, okay. Okay. So
Gary Stokes.
Thanks so much.
Good morning, Your Honor.
Good morning, sir. You were charged with a felony count of violation of the Georgia Controlled Substances Act. You're also charged with improper lane change, driving on a suspended license, and a brake light. Do you understand your charges? You do not have a bond on the felony drug charge, but your bond for the improper lane change is $500. For the driving on a suspended license is $1,500, and for the brake lights is $500. As I stated, you do not have a bond on the felony charge. Your next court date will be September 14th at 8:30 a.m. in room 201. Have a good day.
Thank you.
You're welcome. Is this Aaron Thomas?
Hey, could you grab Aaron Thomas? We're breaking it up now, Your Honor. Aaron Thomas. Is that the Fugitive? I believe so.
Aaron Thomas? Aaron Thomas. Aaron Thomas? Aaron Thomas?
Mr. Thomas is on his way, Your Honor.
Thank
He's
you.
right here.
Thank you.
Yeah, right here.
Good morning, sir. Well, it's afternoon now, but you are charged with no tail lights and driving on a suspended license. Do you understand your charges?
Excuse me?
You are charged with no tail lights and driving on a suspended license. Do you understand your charges?
Oh, yes, ma'am.
For the tail light charge, your bond is $500. For the license charge, your bond is $1,500 for a total of $2,000. Are you able to make bond?
Yes, I had to make a phone call.
Condition of your bond that you should not violate any laws of auto bond. You understand?
Yes, ma'am.
All right. These are misdemeanor offenses, which means you have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing?
No, ma'am.
Your next court date will be September 13th at 8:30 a.m. in room 201. Have a good day.
Okay, thank you.
You're welcome.
Down in that house, the phone should be at.
Jameson Towns,
Mr. Townsend. Right here.
Mr. Towns, good morning. You are charged with reckless driving, speeding, following too close, and improper lane change. Do you understand your charges?
Yes. Yes.
For the reckless driving, your charge is, your bond is $1,500. For the speeding, your bond is $1,500. For following too closely, your bond is $500. And for improper lane change, your bond is $500, for a total of $4,000 in bond. You shall not violate any laws while out on bond. Are you able to make bond?
Yes.
These are misdemeanor offenses, which means you have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing?
No.
Your next court date will be September 13th at 8:30 a.m. in room 201. Have a good day. Ralph Turner.
Say again, Your Honor.
Ralph Turner.
Ralph Turner.
Are you Mr. Turner?
Yes, ma'am.
Good morning, sir. You are charged with defective equipment, driving on the wrong side of the road, possession of marijuana less than an ounce, a felony violation of the Georgia Controlled Substances Act, and possession of a weapon during the commission of a crime. Do you understand your charges?
No, can you say the next to last one again?
A felony count, a violation of the Georgia Controlled Substances Act.
The marijuana?
The MDMA. It is accused that you committed the offense of defective equipment when you were traveling southbound on Terra Boulevard at Sherwood Drive while operating your 2006 Chevy Trailblazer with a defective rear brake light, that you drove on the wrong side of the road when you turned left at the roadway median prior to the affixed proper intersection, that you had in your lap a pack of Bob Marley rolling papers and one black Smith & Wesson M&P Shield pistol hoisted under your left arm. Upon asking you if you were in possession of any drugs or contraband, you freely admitted to possessing marijuana that was located in a small black shoulder bag with a large green marijuana leaf on the outside. And inside the bag, the officer allegedly located two small unsealed baggies containing approximately 14 grams of GLM marijuana and a third clear baggie containing two circular pills, approximately 2 grams weighing on scene, that field tested positive for methyl-deoxymethamphetamine, commonly known as ecstasy, MDMA, that you did freely admit to being in possession of those pills after taking them away from your girlfriend's son. That these incidents occurred in Clayton County, Georgia. On the defective equipment, your bond is $500. On the wrong side of the road, the bond is $500. On the marijuana misdemeanor, your bond is $1,500. On the felony drug charge, your bond is $8,000. And on the possession of a weapon during the commission of a crime, your bond is $10,000, for a total of $20,500. And you shall not violate any laws while out on bond. Do you understand?
Yes.
Are you able to make bond?
Yes.
Your next court date will be September 14th at 8:30 a.m. in room 201. Have a good day.
Turner.
Isaiah Walker,
Your Honor, it's Deputy Horton.
yes.
So I do apologize. Found out what happened to the waiver forms. When they were sent off, your email was spelled wrong. They left a letter out. So I'm going to resend them now the correct way.
The documents that I was missing.
Yes, ma'am. The other half of the waivers that was supposed to be sent off.
Are you talking about applications or waivers? I got all the applications. I'm missing actual warrants and paperwork.
If that stuff hasn't been sent, they haven't been sent to us yet. I can call our supervisor, but Intake said they haven't got any of the fugitive waivers.
No, I'm not talking
Oh,
about
Lord.
fugitives. I have the fugitive waivers. Let me slow down. There are several inmates that were brought before me that you all still had. Mr. Ada, the Spanish speaking male. Then there was Mr. Smith. There was Peyton Alonso, and there was another young lady, Miss Gray. All these people, I never received any paperwork for them, not the applications, the actual warrants or the actual WAAs I did not receive. Usually when that occurs, those people have been bonded out. So that's what I assumed. But then you all had already brought them over. I think there was another gentleman as well, Mr. Mohan or something like that. So these are people who, if they are not bonded out, I need their paperwork so that I can actually sign the documents and actually put them through the system so they're not sitting there.
Yeah, some of them did say they already posted bond, but I'm not sure. But I can double check. I can go to Intake and make sure everything was sent off.
So let's do this. Okay, let's do this. Let's do my last two before you go down there to Intake. I'm going to go back through my list of those who I did not have paperwork for. You can verify whether or not they bonded out. If they did, we're good. If they didn't, we need to get them first appeared today. But let's finish the two we had in front of me. And as far as the applications and waivers, Horton, y'all are good on that, I think. Because I've gotten the other, I haven't had any applications that I'm missing. What I'm missing is the most important paperwork, which are the warrants and the WAAs. So let's get Walker and Westmoreland done, and we can go back and see what's going on with these other individuals, okay? Thank you. Isaiah Walker.
Isaiah Walker? Yes, Isaiah Walker.
Good afternoon, sir. What's your name?
Isaiah Walker.
Mr. Walker, you're charged with attempted window violation, a felony violation of a violation of the Georgia Controlled Substances Act, use or possession of drug-related objects, and possession of a weapon during the commission of a crime. Do you understand your charges, sir?
Yeah, I understand.
So for the window violation, your bond is $500. For the felony drug charge, you do not have a bond. For the use or possession of drug-related objects, the bond is $1,500. And for the possession of a weapon during the commission of a crime, you do not have a bond. And that's based on your status as a probationer. I have set down for you to have a hearing on September 14th at 8:30 a.m. Have a good day, okay?
Said September 14th?
Yes, sir.
All right.
All right, take care. Parents Westmoreland. Are you Mr. Westmoreland? You are charged with aggravated assault by strangulation, false imprisonment, cruelty to children in the 3rd degree. You have another charge of aggravated assault with a deadly weapon. You have another charge of false imprisonment, and you have a charge of robbery by intimidation. Do you understand your charges?
Yeah, I do.
On the cruelty to children, which is a misdemeanor, your bond is $8,000. However, on all the other charges, which are felonies, you do not have a bond at this time. Should you get a bond, the condition of that bond will be to stay away from Tamika Taylor, Alana Taylor, and Tegan Taylor. But as stated, you do not have a bond at this time. Your next court date will be September 14th at 8:30 a.m. in room 201. Have a good day. Ontario Yancey.
What's more?
Ontario Yancey.
He's on his way around. He's walking down right now.
Thank you.
Yes, ma'am.
Mr. Yancey, you're charged with simple battery, cruelty to children in the 3rd degree, aggravated assault by strangulation, and aggravated assault with a deadly weapon. Do you understand your charges?
Yes, ma'am.
On the misdemeanor simple battery, your bond is $8,000. On the misdemeanor cruelty to children, your bond is $8,000. On the aggravated assault charges, you do not have a bond. Condition of your bond, should you get a bond, will be to stay away from Sierra Sparks and Grayson Sparks. But as stated, you do not have a bond at this time. The next court date will be September 14th at 8:30 a.m. in room 201. Have a good day. Before we move on to the fugitives, I want to verify the people whose paperwork I have not received to confirm whether or not they have been bonded out. Give me 1 second to make a list.
What's the list? Alana? Alana. He's here. What are you going down, bro? Yeah, but she probably not today.
Did we get Mr. Edwards now, the add-on?
Repeat that, Your Honor.
Do we have the add-on, Mr. Edwards?
Not just, Your Honor, did you have me send me?
One of those like Evans.
Yeah. Y'all,
Yes.
I have a list of everybody that bonded out.
Okay.
Mr. Arata is one. Mr. Borhin, or I can't pronounce his last name, but his first name.
Mouhian.
No, man, it's the third person. H-A. His first name is Hani, Hani. His last name is Bourouhen.
Okay.
The third person is Gore.
Yes.
Gray. Howard.
Yes.
Smith.
Yes.
Vaughn, and Vaughn.
Okay. So then that means we still need paperwork for Peyton then, right?
Yes, ma'am. I have the paperwork for the passment.
If you can send over the paperwork for Alonzo Peyton and then Mr. Edwards.
I have the.
Oh, is Peyton the fugitive? Allegedly?
I have his paperwork.
I have his paperwork.
I have his waivers down here now as well, his extradition waivers.
Okay, so Mr. Peyton is the alleged fugitive. We have him. And what about the add-on, Mr. Edwards, who was reset from yesterday?
I have a deputy going to pick him up now, Your Honor.
Okay, we'll do the alleged fugitives now. You can bring them forward, and then we will.
I have Mr. Ramondo Brown.
Thank you so much.
You Alonzo Peyton, will you come up here?
Thank you so much. Y'all working hard. We're getting it done. Let's keep going.
We'll tell both of us at the same time. Then you gonna go first. Then we'll go Mr. Brown.
Okay. Okay.
You stand there.
Please state your name.
Ramondo Brown.
Sir.
Alonzo.
All right. Good afternoon, Mr. Brown and Mr. Payton. This is called an extradition hearing. All the rights I advised everyone of earlier also apply to you all, but your hearings are a little bit different in that you don't have any first appearance here before the court. You don't have any charges pending against you here in Clayton County, Georgia, but rather you've been brought to court today because you have charges pending against you in another state, and they are requesting that you return to that state to answer to those charges. Are you in fact Ramondo Brown?
Yes.
Are you in fact Alonzo Payton? Mr. Brown, do you currently have an attorney representing you?
In Virginia, yes.
Mr. Payton, do you currently have an attorney representing you? You each are being charged of being a fugitive from justice. This, Mr. Brown, it is alleged that you entered and remained in the state of Georgia and that you are wanted by Henrico County PD in Virginia for felon weapon possession and that they are intending to extradite you. Mr. Payton, it is alleged that you have entered and remained in the state of Georgia, knowing that you are wanted out of the state of Connecticut for from the fugitive unit for a parole violation for the sale of synthetic narcotics. And they have indicated that they also wish to extradite. This hearing is being conducted pursuant to OCGA Title 17, Chapter 13. As you have heard, it is alleged that you are charged with charges in your respective states and that they wish for you to be returned to those states. For you, Mr. Brown, the state of Virginia. For you, Mr. Payton, the state of Connecticut. You each have a choice as to whether you wish to contest extradition or waive extradition and be returned to the other state without going through the formal extradition process. If you decide that you wish to contest extradition, the court may commit you to the county jail for an initial period of 30 days. During that time, a warrant will be executed and prepared for the Georgia governor's signature, and that will provide for extradition to another state. While the court may consider allowing bonds for each of you, it is our policy not to provide a bond for anybody who is alleged to be a fugitive. So as such, I am denying bond in each of your cases. If you do not wish to voluntarily return to the state of Virginia, Mr. Brown, or the state of Connecticut, Mr. Payton, you can file what's called a writ of habeas corpus to contest extradition. The writ of habeas corpus can only contest these following 4 things. Number 1, whether the extradition documents are in order on their face. Number 2, whether you are charged with a crime that actually exists in the state of Virginia for you and the state of Connecticut for you. You may also determine whether or not you are the named person that is named in the request for extradition. And you may also contest whether or not you are in fact a fugitive from justice. You are not able to contest the issue of your guilt or innocence in this state. As such, you are entitled to the amounts of counsel. However, if the state is not able to extradite you within 30 days, you may be committed to the county jail for an additional 60 days while you are awaiting extradition. After 90 days, if your respective states have not come to retrieve you, you will be released. So I'll ask you first, Mr. Brown, do you wish to voluntarily return to the state of Virginia to answer to these charges?
Yes.
Mr. Payton, do you wish to voluntarily return to the state of Connecticut to answer to these charges? I can't hear you, sir. I'm sorry.
I think yes.
Okay.
Yes.
Oh, you will need to sign your waivers. You're going to get several copies, or excuse me, several originals of the waivers. Make sure you sign in the correct spot where you're supposed to sign. I will get my portion today and I will sign my portion today and I will return them. So nothing I'm going to do is going to hold you gentlemen any longer, okay? So the courts are going to send everything over and your respective states will need to come and retrieve you since you all are willing to voluntarily return. Have a good day. Are we set for Edwards? Or are we still waiting? Do I have time to take a quick stretch break? I've been sitting here for 2 hours.
Yeah, we're still waiting, ma'am.
Thank you.
All right, he has waived his right to be here. I'm going to find probable cause. I'm going to set bond in the amount of $500, require he have no contact. Madam Interpreter, bear with us just one moment. He's not here, so you don't need to interpret, but we'll have one right after this. He used to have no contact directly or indirectly with Elizabeth Marie Sanchez Rivera, maintain separate residences, appear one time with law enforcement to collect personal effects, no drugs, no alcohol, no weapons, no firearms, and I'll appoint the office of the public defender.
Yes, 2 cases, Your Honor.
He has 2 cases. So he does. Violation of pretrial release. That is by a warrant. I did see that earlier by Judge Wilson. Bond is set in the amount of $3,500. Judge Wilson has directed me as the initial appearance judge not to modify that bond amount. Thank you for reminding me of that.
You're welcome.
You wouldn't have let me go far without it. All right, next I have Willie Orozco Fuentes. Madam Interpreter, I apologize for butchering these Spanish names. I'm doing the best I can.
Don't worry, Your Honor.
All right, Mr. Orozco Fuentes has the headset on.
Sí, le escucho.
Can
There is contact, Your Honor.
Okay. All right, good. All right. Okay. All right. Good morning, ma'am. Would you raise your hand to be sworn by the clerk? Madam Interpreter, I think this gets a little confusing because we've got The defendant, he had a headset on, the witness does not have a headset. I can't see from.
Okay.
So I'm gonna need you to do that over the loudspeaker. I'm sorry, Madam Interpreter.
Señora, por favor, levante la mano derecha para prestar juramento.
Swear or affirm the testimony you're about to give today is the truth, the whole truth, and nothing but the truth.
Juri promete que el testimonio que va a prestar será la verdad, solamente la verdad y nada más que la verdad. Yes.
All right, good morning, ma'am. Tell me your name, please. You put your name.
Buenos días, señora. Puede bajar la mano. Por favor, dígame su nombre.
Rufina.
Rufina.
All right, ma'am.
¿Cómo?
You have been identified as the victim of a domestic violence battery.
Señora, usted ha sido identificada como la víctima de una agresión física por violencia doméstica.
The defendant is Mr. Orozco Fuentes.
El acusado es el señor Orozco Fuentes.
Part of my job this morning is to find probable cause to believe that a crime has been committed and to set conditions of release.
Mi trabajo esta mañana es verificar si existen indicios de criminalidad, del ilícito y establecer las condiciones de la fianza.
Ms. Tyner from the State Attorney's Office, would you like to inquire of the witness?
Yes.
¿Puede hacer algunas preguntas a la víctima? Sí.
Good morning. Do you reside with Mr. Fuentes?
Buenos días, ¿usted vive con el señor Fuentes?
Sí. Are you,
Yes.
are you seeking contact with him?
¿Usted desea tener contacto con él?
No sé.
I don't know.
Are you afraid of him?
¿Usted le teme?
No.
No.
Do you want him to return to the residence?
¿Usted desea que él regrese a la casa?
Sí.
Yes.
So you would like to have contact with him at this time?
Así que entonces usted desea tener contacto con él?
Sí.
Yes.
No further questions from the state.
La fiscalía no tiene más preguntas.
All right, can you tell me why you want to have the defendant return to the home that you share?
Señora, ¿podría usted explicarme por qué desea que el acusado regrese al hogar que ustedes comparten?
Porque ahí estamos viviendo los dos y yo no pensé que me iba a llegar hasta acá solo por llamarlo, solo porque esa noche él me agredió y lo único que pensé fue en llamar para poder salvarme de él, pero no quiero que tenga cargos de nada y sí quiero que él regrese a la casa y así.
Well, because only the two of us live there, and I didn't expect this to go this far when I called, because you see that night he hit me, and I called because I wanted help getting out of that situation, but I don't want to press any charges, and I don't want him back.
Okay, do you understand that part of my job is to protect the citizens of Orange County and to protect you specifically from any future danger? Do you understand that?
Señora, ¿usted entiende que parte de mi trabajo es proteger a los ciudadanos del condado de Orange, en particular a usted, de peligro y de peligro futuro, de incidentes futuros? ¿Esto usted lo entiende?
Sí, lo entiendo.
Yes, I understand.
All right, so I have a choice of ordering that the defendant have no contact with you at all, directly or indirectly, and that you maintain separate residences, and that would be a condition of his release until the case is over.
Yo tengo que tomar una decisión. Yo podría ordenar que se prohíba todo tipo de contactos entre ustedes, ya bien sea directo o indirecto, que se le prohíba la convivencia en lo que se resuelve la causa.
I also have the option of ordering only that he have no hostile contact with you and that he could return home, you can maintain your residence together, but he can have contact with you, but if you feel that contact becomes hostile or angry or dangerous, you can call the police and his conditions of release could be revoked.
También tengo la opción de permitir el contacto entre ustedes, pero con la condición de que el contacto sea sin hostilidad de parte de él hacia usted. Esto permitiría que él regrese a la casa, que ustedes puedan convivir, y si en algún momento este contacto de él hacia usted se torna hostil, agresivo o peligroso, usted puede llamar a la policía y las condiciones de su libertad serán revocadas.
So you understand those two choices that I have to make.
Así que entonces, señora, ¿entiende usted estas dos opciones que tengo yo y que tendré que tomar una decisión?
Sí.
Okay.
Yes.
So do you want me to order no contact and maintain separate residences, or no hostile contact and he can come home as long as he is not hostile toward you?
Así que entonces, señora, ¿usted prefiere que yo ordene que se prohíba el contacto entre ustedes por completo? Él no podrá regresar a la casa, o por el contrario, que ordene que se prohíba la hostilidad entre ustedes, él podrá regresar al hogar, pero no podrá tener hostilidad en su contra.
Sí.
Okay.
Yes.
All right, which one? No hostile
¿Cuál de
contact?
las? I'm sorry, Your Honor.
I'm sorry. No hostile contact or no contact at all?
¿Cuál de las dos, señora? ¿Es que se prohíba la hostilidad o que no haya contacto en absoluto?
La primera.
The first one.
I forgot which one was the first one. I think no hostile contact. Is that what you'd like?
Ya se me olvidó a mí cuál era la primera. Creo que esa era contacto sin hostilidad. ¿Esa es la que usted prefiere?
Sí.
Yes.
All right. Defense counsel, I failed to give you an opportunity. Did you have any questions for this young lady?
Just, Your Honor.
Al abogado de la defensa, disculpe, no le di la oportunidad de hacerle preguntas a la joven. ¿Tiene usted alguna pregunta que hacerle? Brevemente, sí, su señoría.
Ma'am, did you come here with the intention of posting his bond today?
Señora, ¿vino usted aquí hoy con la intención de prestar la fianza para él hoy?
¿Qué es eso?
What is that?
Nothing further, Your Honor.
All right.
No tengo más preguntas, su señoría.
Ms. Tyner?
Yes, before the court makes a decision. Despite the testimony of the victim today, based off of the affidavit, the state would be asking for no contact, separate residences, and no weapons or firearms. While I appreciate and am thankful that the victim did appear today, this is a very serious accusation. There are multiple instances in this affidavit that put me at fear for her safety, and we would be requesting that they have absolutely no contact.
Su señoría, antes de que tome la determinación, y yo escuché las declaraciones de la víctima, pero a pesar de esto, nosotros estamos solicitando que se prohíba por completo el contacto entre ambos, que se le prohíba la convivencia y que se le prohíba a él la tenencia de todo tipo de armas y armas de fuego. Y esto es debido a que nos encontramos ante una situación muy seria. En el documento acusatorio se describen múltiples instancias y a mí me preocupa la seguridad de ella.
Any other questions?
No, Your Honor.
All right.
¿Alguna otra pregunta? No, su señoría.
While I appreciate the victim appearing today and attesting to the fact that she is not afraid of the defendant, I share the state's concern for ongoing contact.
A pesar de que yo le agradezco a la víctima que se haya presentado aquí hoy, que haya hecho sus declaraciones, me temo que yo comparto la misma preocupación de la fiscalía y en cuanto a la peligrosidad del acusado.
So I'm going to find probable cause and I'm going to set bond On the felony battery by strangulation, I'm gonna set bond in the amount of $1,000.
Así que entonces determino que existen indicios de criminalidad, se fija fianza en cuanto a la acusación de agresión física por estrangulamiento, $1,000.
And on the domestic violence battery, I'm gonna set bond in the amount of $500.
En cuanto a la agresión física por violencia doméstica, la fianza será de $500.
I'm gonna require the defendant have no contact directly or indirectly with the identified victim in this case, Francisca Vasquez Coronado Rufino.
Se le prohíbe todo tipo de contacto, ya bien sea directo o indirecto, al acusado con la víctima Francisca Vázquez Rufino Coronado.
Parties are to maintain separate residences. The defendant may return to the residence they share one time to collect personal effects.
Se le prohíbe la convivencia con la víctima, se le permitirá regresar a la casa que comparten en una ocasión acompañado de las autoridades para recoger sus pertenencias.
In the company of law enforcement.
Tendrá que regresar acompañado de las autoridades.
The defendant is not to consume alcohol or drugs, possess weapons or firearms.
Al acusado se le prohíbe el consumo de drogas y alcohol y se le prohíbe la tenencia de todo tipo de armas y armas de fuego.
And I'll appoint the public defender to represent him.
Se designa el abogado de oficio para que le represente.
Your Honor, could we just have the maintain separate residences? As far as the no contact is concerned, he's scoring 0. I'd imagine, but for the charge, he'd be eligible for pretrial release. I mean, she came down here saying that she wasn't afraid. From a trial attorney and public defender's perspective, this is going to derail his life and likely derail her life because they're in a living situation. Now, he, I'm presuming, doesn't have any money, not too many resources to go find a new place. So that's already going to screw him up. But as far as having any sort of relationship with her where she can assist him in finding a new place, I wouldn't want that to be taken away either. But the no contact just seems like it's overreaching. I don't even know why the state is suggesting that. The alleged victim is more than qualified to speak for herself. She indicated she's not afraid. She wants contact with him. I think that we're just going too far by having no contact completely in this case.
Su señoría, en cuanto a esta orden de prohibición de contacto, el acusado en la hoja de cálculo ha arrojado un 0 y creo que esto es para ambas acusaciones lo que haría que él cumpla con los requisitos de la libertad provisional. La víctima ha venido aquí, ha declarado que ella no le teme y esto, para serle franco, esto va a descarrilar la vida de él, también la vida de ella, porque hasta donde tengo entendido, él no tiene dinero para buscar un nuevo lugar donde vivir y esta prohibición de contacto que ella ni siquiera podrá ayudarle a conseguir un nuevo lugar, a mí me parece que es ir demasiado lejos.
Ms. Tyner, does separate residences and no hostile contact address the state's concern, given that the identified victim indicates that she is not afraid of the defendant?
Licenciada, el que se le prohíba la convivencia y se permita el contacto sin hostilidad entre ambos, ¿esto cubre la preocupación de la Fiscalía?
No, Your Honor, it does not. And based off the affidavit, he was gathering items to leave anyways. It's our contention that while the victim may be able to speak for herself, the defendant is also a grown man and he can find himself other living arrangements.
No, su señoría, no. Y según el documento acusatorio, el acusado se encontraba recogiendo sus pertenencias para marcharme. Y de la misma manera que la víctima tiene capacidad de hablar por sí misma, el acusado ya es un hombre hecho y derecho que tiene la capacidad de buscar un lugar donde vivir.
Well, I think that ordering that the parties maintain separate residences will satisfy the main concern that I have for the victim's safety. I'm not sure what permitting no hostile contact rather than no contact will make a difference since they're going to be residing in different residences. So I'm going to stay with my initial ruling.
Bueno, yo creo que el ordenar que se le prohíba la convivencia y que se permite el contacto, pero sin hostilidad entre ambos, podría atender a las preocupaciones principales en cuanto a la seguridad de la víctima, pero no estoy seguro qué diferencia haría esta permitir el contacto sin hostilidad, así que voy a sostener el dictamen original.
All right, thank you, good luck.
Gracias, buena suerte.
Thank you for coming in.
Gracias por venir.
Next, I have Milaniela. Ms. Gill is charged with domestic violence battery. The victims appear to be Natasha Oriero and Ethan Morales.
She does qualify for PTI.
She does qualify for PTI. All right. We have, I'm going to make an educated guess. Is this Ms. Oriero?
Yes.
Okay. Do you need the services of an interpreter, Ms. Oriero, or can?
No.
Okay, because my Spanish is terrible.
It's okay.
Okay. All right, Ms. Oriero, as you may have heard earlier, it is my job to impose conditions of release. One of those conditions is whether Ms. Gill is to be permitted to have contact with you. What do you want me to know as far as what you think would best safeguard you from any future danger?
I'm not afraid of her. I want her to come back.
Okay. Do you? What is your relationship with Ms. Gill?
She's my mother.
Okay. You live together at the apartment on Buena Place?
Yes.
And if I permit your mother to return home in order that she have no hostile contact with you, would you be able to express yourself and let her know that what she's doing you find to be hostile and ask her to stop?
Yes.
And if she refuses to stop, will you, in an effort to protect yourself and others, contact law enforcement with the understanding that calling the police would result, but maybe, in her conditions of release being withdrawn? Do you understand that?
Yes.
Ms. Tyner, did you have any questions for Ms. Oriero?
No, Your Honor, I believe you covered it all.
Okay. All right. Defense, any questions?
No, Judge.
Counsel, I'm spacing your name.
Bolin.
Bolin?
Mr. Bolin.
All right. Knew it started with a B. I just couldn't remember. Mr. Bolin. All right, I'm gonna find probable cause. I'm gonna set bond in the amount of $500.
She qualifies for PTR.
I'll go ahead and release her on pretrial release if she would prefer it.
And conditions. I have a question.
Okay, before you ask me that question, make sure that Mr. Bolin has a chance to, I think he's looking something up, and you may want to ask him first.
You're getting out soon. Soon. We'll talk later. 2 weeks. Oh, it's in 2 weeks.
I'm getting to it. You're ahead of me
Out.
today.
You gotta process you to get out.
So I have to come back?
All right.
Later, you gotta
All
call
right.
us first.
Ms. Gill, let me
You have
explain.
my phone number. Call.
I've never been in this situation.
I understand.
You gotta leave now, so.
The thing is, I'm supposed to go to Colombia to make an dentist appointment, and I
All right, Ms. Gill.
to leave
Ms.
on
Gill.
Tuesday.
Ms. Gill, the only thing that I'm doing today is I'm determining whether there is probable cause to believe a crime was committed and you're the one that committed the crime. The other thing that I have to do is I have to set conditions of your release. I'm going to set those conditions. You are going to have a new court date in the future. I'm going to appoint a lawyer to represent you, You'll have an opportunity to follow up with your lawyer and talk to your lawyer about what you can and cannot do once being released. So those are the only matters to be discussed today. I know you have questions. I know that you feel the most direct way to get answers to those questions is to ask me. I'm going to advise you that it's not in your best interest to say anything more about the case. We have a prosecutor here taking notes. These proceedings are being recorded. You may say something in an effort to understand the process or get answers to the questions you've got that may not be productive and may hurt your case. All right? So what I'm doing is I'm based on the testimony of your daughter that she's not afraid of you. I'm going to release you on pretrial release. You're going to be given instructions from pretrial release as to what needs to happen to follow up with this case. The court paperwork will also indicate that if you change your mind and don't want pretrial release, you can post bond in the amount of $500. I don't know if that complicates you all with pretrial release, but I have a feeling that the minute Ms. Gill leaves, there's a change and we have to come back. So it's either pretrial release or a straight bond. I'm ordering, Ms. Gill, that you have no hostile contact with either Ethan Morales or Natasha Oriero. No hostile contact means you can have contact, you can return to the home you share. If either one of these folks indicate to you that they believe you are acting in a hostile fashion, it is your obligation to stop behaving that way and in your best interest to leave the house. If you continue, even though you may not think you're acting in a hostile way, they can contact law enforcement and your conditions of release will be revoked. You're not to consume any alcohol or drugs. You're not to possess any weapons or firearms. And I'm appointing the Office of the Public Defender to represent you on this case going forward. That's all that I have to do today. I wish you good luck. You can follow up with your assigned Assistant Public Defender, and he or she can answer any further questions that you have. Thank you, Ms. Oriero, for appearing today. Carlos Juan Lopez Colon. Do we have Zulika Gomez?
Good morning, Your Honor.
Good morning, Ms. Gomez. Do you need the services of the interpreter?
No, sir.
Okay. All right, Ms. Gomez, would you raise your right hand to be sworn by my clerk, please?
You swear or affirm the testimony you're about to give is the whole truth, the whole truth.
Yes, sir.
All right, can you tell me your name, please?
Zulika Gomez.
All right. Ms. Gomez, I need you to speak just a little louder. I can hear you barely. I want to be able to hear what you have to say, okay?
Okay.
All right. Ms. Tyner, did you want to inquire of Ms. Gomez?
Yes. Good morning, Ms. Gomez.
Good morning, ma'am.
Are you seeking contact with the defendant today?
No, ma'am.
Okay. Are you afraid of the defendant?
Yes, ma'am.
I'm sorry, I know that's a difficult question. And do you currently reside with him?
I picked up my belongings. I'm no longer at the residence.
Okay. No further questions at this time.
All right. So I understand that she does not want contact and that she's no longer at the residence. Is that what she said?
I believe so.
Mr. Boland, did you have any questions of Ms. Gomez?
No, Your Honor.
Okay. All right. I've reviewed the charging affidavit. I appreciate Ms. Gomez appearing today to address the court. I'm going to find probable cause. I'm going to set bond in the amount of $500. I'm going to
qualify for PTR.
He does. I'll give him the option of pretrial release. So it's either going to be straight pretrial release or a $500 bond. I'm required that Mr. Lopez Colon have no contact, directly or indirectly, with Zulika Gomez. Mr. Lopez Colon, I want to make certain that you understand what that means. That means no telephone calls, text messaging, instant messaging, calling friends to contact her, sending her flowers, or a lovely fruit arrangement. None of that's going to happen. All right? Should Ms. Gomez reach out to you and want to have contact with you, that does not excuse you from the conditions I have imposed. Court has jurisdiction over you, but not over Ms. Gomez. I'm going to require that you, if you're going to maintain separate residences, if it turns out she's moved out and you're going to return to the location where this occurred on Queen Anne Drive, you can stay there and she can stay elsewhere. If you wish to move out of that location and Ms. Gomez is there, you're entitled to return one time with law enforcement to collect personal effects. You're to possess no weapons or firearms, consume no alcohol or drugs, and I'm going to appoint the Office of the Public Defender to represent you. All right, sir, good luck. Ms. Gomez, thank you for appearing today. You're free to go as well.
Thank you, Your Honor.
Thank you. Next, I have Juan Rivera Santana. I think I nailed that name, Madam Interpreter.
Yes, you did, Your Honor.
Do we have Hector Cartagena? Do we have any witnesses or any victims on Mr. Rivera Santana? No, Your Honor. Okay. All right, Mr. Rivera Santana, I've reviewed the charging affidavit. I'm going to find that there's probable cause. I'm going to require that you have no contact directly or indirectly with Hector Cartagena, that you maintain separate residences. You're permitted to return to the location of this offense one time in the presence of law enforcement to collect personal effects. No weapons, no firearms, no alcohol, no drugs. Does Mr. Rivera Santana qualify for pretrial release?
Yes.
Give him the option of either pretrial release or $500 bond. I'll appoint the Office of the Public Defender. Good luck, sir. Next, I have Guillermo Miguel Diego. All right, Mr. Rivera Santana.
Necesito hacerle una pregunta, por favor.
I need to ask you a question, please.
Okay, before you ask me a question, I want you to understand that my job here today is to determine whether there is probable cause to believe that crime was committed and whether you're the person who committed the crime. My other job is to determine conditions of release. I've done those two things. Those things are subject to modification by the judge to whom your case is assigned on a later date. You are free to ask me a question. However, please understand that these proceedings are being recorded and the Assistant State Attorney is here taking notes. You may ask me a question that may say something about your case that may not be helpful. It's not likely to change my imposition of conditions of release. You're free to ask me the question, but I want you to understand that any question that you've got about the case itself can be answered once you get out of jail. Knowing that you have Mr. Boland standing next to you as an assistant public defender, did you want to ask me a question? Did you want to ask your lawyer a question? Or did you want to leave it for another day?
Yo se la voy a hacer el abogado. Lo único que yo digo es que yo no sé inglés, no sé escribir, no sé leer y tengo esas dificultades, por eso es que abusan conmigo. Pero esto es Cartagena. Yo estoy a cargo de la MAI porque la MAI tiene diálisis. ¿Ah? La MAI tiene diálisis y él no la atiende porque él tiene una nena de 7 añitos y está viviendo en casa, y yo creo que esa palabra de que está viviendo en casa con la nena, yo creo que no. Y él duerme en el cuarto con la nena, es una. Entonces, si la casa yo la compré, ¿por qué yo me tengo que ir de mi casa si el que se tiene que ir de él, si él tiene un buen trabajo?
Well, first, I want to say that I don't speak English, that I can't write, I can't read, and this is why people abuse me. You see, this person, Hector Cartagena, I in charge of his mother because she has to receive dialysis, and he doesn't take care of her. Because he has a 7-year-old daughter, and Hector Cartagena is living in my house, and he sleeps in the same room with his daughter. And I don't understand why, since I was the one that bought the house, why I am the one that has to leave. Because Hector Cartagena works.
All right, sir. I can't sort that out for you. I'm certain it's something that can be brought up before another judge on another day. I have imposed the conditions I've imposed. That will conclude your hearing today. Good luck, sir.
Ah, no.
Next, I have Guillermo Miguel Diego. Mr. Miguel Diego is charged with operating a motor vehicle without a valid driver's license and also driving while license suspended or revoked with knowledge. I'm going to find probable cause on both charges. I'm going to set bond on the driving while license suspended or revoked in the amount of $500. No valid driver's license in the amount of $100. I'm going to appoint the office of the public defender to represent him. Good luck, sir.
Can we inquire if he qualifies for pretrial release?
Sure. Does he qualify for pretrial release? Immigration issue?
He has an active.
Okay, so he's not gonna leave the jail until he's transported to Seminole County?
Unless he post a bond.
Okay. Okay. All right, good luck, Mr. Miguel Diego. Next, we have Josue Ruiz Gomez. Mr. Ruiz Gomez is here on an out-of-county warrant from Polk County. The warrant forms the basis of probable cause. The bond set in that warrant is $1,500. Court will not disturb the bond set in the out-of-county warrant. Good luck, sir. Those are all the Spanish cases I have. Is that what you have? I'm getting a nod. Okay. All right. Madam Interpreter, thank you so much for your help today. You enjoy the rest of your day.
Thank you, Your Honor, you as well.
All right. Next, we have Euclides Esteban Peralta.
Yes, Judge.
All right. This is Mr. Peralta's here on a violation of domestic violence injunction. Do we have the victim in this case? Okay. I've reviewed the charging affidavit. I find probable cause based upon the existence of the domestic violence injunction. I'm going to set bond in the amount of $2,500. And I am going to appoint the Office of the Public Defender to represent Mr. Peralta. Good luck, sir. Well, he's already got an injunction, so I guess the conditions would be no contact directly or indirectly, no return to the location contained in the injunction, which I believe is 8621 Snowfire Drive. I'm also going to require that Mr. Peralta possess no weapons or firearms and consume no alcohol or drugs. Thank you, Madam Clerk. Tracy Winslow. Morning, Ms. Winslow. Do we have?
Yes, Your
Michael Campbell?
Yes.
All right. Would you go ahead and swear Mr. Campbell?
Raise your right hand. You swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right, good morning, sir. Tell me your name, please.
Michael Campbell.
All right, Mr. Campbell. Mr. Campbell, you've heard me explain this to several folks before you, so hopefully you're paying attention. It's going to sound familiar. My job is to determine whether there's probable cause to believe a crime has been committed, and Ms. Winslow committed the crime. My other job is to determine what conditions of release would be appropriate. Since you're here, it's helpful for me to hear from you as far as whether you want me to order that she have no hostile contact, meaning she can return to the residence that you share, as long as she's not, doesn't behave in a hostile or violent way toward you. Alternatively, I can order that she have no contact directly or indirectly and maintain separate residences. I think I'm going to continue with the pattern and find out whether Ms. Tyner has any questions for you.
Yes, thank you, Your Honor. Good morning.
Hey.
What's your relationship with Miss Winslow?
Work together. We've been together for 10 years.
Has anything like this ever happened in the past?
No.
Are you afraid of Miss Winslow?
No.
Do you want her to return to your residence?
Yes, please.
And you're seeking contact with Miss Winslow?
Yes.
Okay.
We're raising a 13-year-old daughter.
Okay. All right, Mr. Boland, I'm sorry, Ms. Tyner, were you done?
I'm finished, thank you.
No questions, Judge.
All right. All right, Ms. Winslow, I find probable cause based on the charging affidavit. Does Ms. Winslow qualify for PTR?
Yes, Your Honor.
All right, I'm going to release her on pretrial release. I'll give her an option of a bond if she wants to post a $500 bond instead. Ms. Winslow, I'm going to order that you not have any hostile contact with your partner, Mr. Campbell. What that means is you're going to be permitted to return to the home that you share. You're not to behave in a violent or hostile manner toward him. That is in the eyes, his eyes, not yours, your eyes. If he expresses to you verbally or non-verbally that he feels as though you're being violent or hostile toward him, it's your obligation to leave him and not continue that behavior. Even though you may feel as though you're not being hostile, if he feels that way, he can contact the police, and your conditions of release will be withdrawn. So you can return to the home you share, no hostile contact. I'm going to require that you not consume any alcohol or drugs, that you possess no weapons or firearms, and I'm going to appoint the Office of the Public Defender to represent you. All right, good luck. Thank you, Mr. Campbell. You have a good day now.
This was as much my fault as hers. Just want that known. Takes two to tango.
I understand. What you can do is you can follow up and talk to the state attorney's office. They're in charge of determining how this is going to go. You might want to share that information with them.
Okay.
Okay. All right, thank you, sir.
All right, thank you.
Dario Guerrier.
Yes, man. Yes, sir. I look like Sean Reeves. I just wanted to let the court know just something.
Okay. All right, Mr. Guerrier is currently, it looks like he's currently out on a misdemeanor trespass in occupied structure. He's before the court on a charge of retail theft, resisting an officer without violence, and assault. On this case, this is the 7-Eleven on Vineland Road. I've reviewed the charging affidavit. I find probable cause. I'm going to stay the bonds in the amount in the charging affidavit. $500 for the retail theft, $100 each for the resisting and the assault, for a total of $700. What's the state's position on taking action on the outstanding trespass?
Since there's bonds in this case, we have no preference.
Okay, I'm going to take no action on the 2022 MM 57665. And I'm going to appoint the Office of the Public Defender to represent Mr. Guerrier. Mr. Guerrier, I'm also going to require as conditions of his release. Mr. Guerrier, pay very close attention. You are not to return to the 7-Eleven located at 3355 Vineland Road. You can go to a different 7-Eleven, I guess, maybe become a Wawa customer, but don't return there. No good comes of that. No alcohol or drugs, no weapons or firearms, no contact with the victim, whose name is Muhammad Shutai. And that's contained in the charging affidavit. If you need me to spell it, I can.
Your Honor, the defense does challenge probable cause on the finding of assault in this case. I
Okay.
believe the officer is referencing,
Yeah, he attacked me.
well, there's that. And the officer referencing the alleged statement by Mr. Gear that he said he would kill him. Assault is more than just that. There has to be a present ability to do so. There's nothing to indicate that he was threatening to hit him and then that the alleged victim then perceived that as an actual, I guess, threat of harm.
All right, State?
Not, actually,
The state's in agreement. We have no objection to RORing on that charge.
All right, I'll ROR him, get the white out, Mr. Clerk. I'll ROR him on the assault. So that's going to be a 500-hour bond on the petty theft and the 100 on the resisting. All right, thanks, folks. Next, I have Wayne Jones.
excuse me, sir.
Mr. Guerrier? We're done. Thank you, sir. Next, I have Wayne Jones.
Yes, sir.
Good afternoon, Mr. Jones. Mr. Jones is charged with trespass on property after warning.
Your Honor, he's having trouble hearing you.
Okay. Do we have a hearing assist?
I think it was just loud behind him if we can.
Okay. Will it work if I just talk into the microphone really loudly, or does he need the?
Oh, he's got it.
That's why we have that. Want to keep the COs busy too. They were getting a little bored over there.
That's better.
Okay, can you hear me all right, Mr. Jones?
Yes, Your Honor.
Okay, good deal. All right, Mr. Jones, you're charged with trespass on property after warning.
Yes, sir.
Apparently, this took place at the Wawa gas station on 1200 West Colonial.
Yes, sir.
I'm going to find, based upon the charging affidavit, however brief, there's probable cause for that. Did Mr. Jones want to resolve this case today, perhaps, Mr. Bolin, or?
I believe so, Your Honor. He has an adjudication, credit time served, court costs, no return to Wawa and 1200 West Colonial. I believe he indicated in the back he would like to accept an offer. Is that right, Mr. Jones?
Yes, sir.
All right. Did you want me to do this orally, or did you have a plea form filled out? It matters
I don't have
not.
a plea form, Your Honor. I cover all of the rights they waive in the back, but
That's fine. I don't think we need a plea form. Has Mr. Jones already been sworn? Why don't we go ahead and swear him?
Sir, raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. Good morning, sir. Tell me your name, please.
Wayne Jones.
All right. Mr. Jones, you are charged with the offense of petty theft. I'm sorry. You were charged, let me start again. You're charged with the offense of trespass on property after warning.
Yes, sir.
This is a first-degree misdemeanor. Your lawyer tells me you want to resolve this case today by entering a plea of no contest. Is that what you want to do?
Yes, Your Honor.
You understand that you're presumed to be innocent of this charge, and I'll release you today. If you wanted to enter a plea of not guilty, you can come back another day. On that day, you could have a trial. You'd be entitled to have a jury impaneled. You could hear the evidence from the state. You could have your lawyer cross-examine those witnesses from the state. You could call your own witnesses, testify on your own behalf, or remain silent. And by entering this plea, you're giving up all those rights. You understand that, right?
Yes, sir.
Has anyone pressured you or forced you against your will to enter this plea?
No, sir.
Are you under the influence of alcohol or drugs today that may have impaired your ability to think clearly?
No, sir.
And you understand that if you're not a U.S. citizen, you could be deported by entering this plea?
Yes, sir.
All right, sir, I'm going to accept your plea of no contest to the charge of trespass after warning. I'm going to adjudicate you to be guilty of that offense. It appears as though you have 2 days credit in the Orange County Jail, so I'm going to sentence you to the 2 days and give you credit for those 2 days. That means you're going to be going home today, all right? You're going to be released today. I'm going to require that you not return to the Wawa gas station located at 1200 West Colonial Drive. No good comes of you going back there. It'll only create trouble for you. Court costs are mandatory. I'm going to give you up to a year to pay them off.
Your Honor,
Yes.
can we reduce those to a civil judgment?
Sure, sure. I'll make that a civil judgment, so when you come into some money, you can pay that off at any time that you like, Mr. Jones.
Yes, sir.
All right, so we got adjudication, credit for time served, no return, and civil judgment on the court costs. All right, Mr. Jones, I've accepted your plea. I've sentenced you. If you feel that sentence is an illegal sentence, you can appeal that sentence. If you want to appeal, your appeal has to be in writing. And if you You have to file it within 30 days, and if you cannot afford an attorney for that appeal, I can appoint one. Although Mr. Boland helped you out today, I'm not going to find that I've appointed him previously, so there's not going to be a public defender fee. It'll save you $50.
Thank you.
Okay, sir? Good luck. Stay out of trouble now, all right? Christopher Volosin? All right, so Mr. Volosin is here before us on a charge of burglary to an occupied dwelling with an assault or battery and domestic violence battery. I reviewed this yesterday. This involves a shooting. I've reviewed the charging affidavit. I find there's probable cause. Mr. Boland, any challenge to probable cause?
No, Your Honor.
All right. I am going to, oh, I'm sorry. I got on a roll there. Mr. Clerk, would you go ahead and swear this young lady?
Raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right, good morning. Tell me your name, please.
Michelle?
Michelle. All right. Michelle, what's your relationship with Mr. Volosin?
He is the father of my son.
Okay, all right. I'm going to let the Assistant State Attorney, Ms. Tyner, ask you some questions. Listen to her questions and answer them as loudly as you can for my and her benefit, and as well as Mr. Volosin.
Yes, Your Honor.
You may inquire.
Good morning. You just stated your relationship, I'm sorry. Are you seeking contact with Mr. Volosin today?
I don't want contact with him, but we have a child, so I'm not sure how to navigate that moving forward.
Understandable. Are you afraid of him?
At this point in time, I would say yes.
And you said he's the father of your child. Do you two reside together?
No, ma'am.
Okay. No further questions at this time, Your Honor.
All right, what about the, it appears as though this also involved another gentleman.
Yes, Your Honor.
So we've got Ms., how do you, Michelle, you pronounce your name Lipay?
Lippi?
Lippi. I was due to get it wrong. We also have Jeff Bardwell. Is Mr. Bardwell here to address the court? No?
Joseph Nieb.
Okay.
I think Jeff Bardwell is the friend. Yes.
Oh, that might be, I'm sorry, that might be Christopher's friend. This is a very dense
Yeah.
charging affidavit. There's a lot of names and facts in here. All right.
Yes.
All right, Mr. Boland, did you have any questions for Ms. Lippy?
Not at this time, Your Honor.
Okay. All right. All right, Ms. Lippy, anything else you want me to know?
I plan on going on Monday and getting a restraining order so that he cannot come to my home anymore.
Okay.
We do have a child, so I have to figure out how to navigate that moving forward, but I'm trying to make it so that he can no longer come to my residence.
All right, I can't give you advice, but I'm going to explain before you leave as to what's going to happen. Ms. Tyner?
And I just wanted to let the court know, in the past, we have authorized contact through an app called Talking Parents that allows individuals to have contact with the children, for the children, and then that way there's no contact outside of that.
There's also Family Ties, which I think also will work. We're going to cover some of that. As you may have heard me explain to other folks, my job today is to determine whether probable cause exists that a crime was committed and that Mr. Volosin is the one that committed the crime, and then set conditions of release. And I've taken testimony from Ms. Lippy, Michelle Lippy, who is the mother of Mr. Volosin's child. Having reviewed the charging affidavit, I find that there is probable cause for the offense of burglary of an occupied dwelling with an assault or battery, which is a very serious offense. I'm going to set bond in that case in the amount of $5,000. On the domestic violence battery, I'm going to set bond in the amount of $500. That total will be $5,500. I'm gonna require that, Mr. Velosan have no contact directly or indirectly, with Ms. Lippy. The way that works is, I know that you have a child in common. I know that's gonna require some contact. That no contact order is gonna be with the exception of through organized, supervised parenting, such as family ties or talking parents. I haven't heard of that one before. What that means, Mr. Velosan, is I have jurisdiction over you. I don't have jurisdiction over your child's mother. That means that should you hear from her, that does not relieve you of your obligations under the conditions of the release that I am imposing.
Sir.
All right? So no contact means no text messages, IMing, talking to other friends to talk to her, sending her flowers or gifts, all right?
Sir.
No contact at all. You will be permitted to set up whatever that is that you're gonna set up.
Sir.
If you need to return to the home that you share, you can go one time in the presence of law enforcement. Gotta make sure you have a police officer with you, or it doesn't satisfy the condition I'm imposing, and it will result in a revocation of your conditions of release.
Sir.
And that's gonna be as long as you can convince the law enforcement officer to stand by. It's 5 or 10 minutes for personal effects. You're not moving furniture, okay?
Sure.
All right. You are, during the time of your release, not to consume any alcohol or drugs,
Sir.
possess no weapons or firearms. Any firearms or weapons that you have in your possession are gonna be turned over to the sheriff's office for safekeeping, within 72 hours of your release.
Yes, sir.
Can we include a no contact order with the other two victims?
All right. I understand the other two victims are also Jeff Bardwell.
N-
Is that right?
No.
No? Why don't you tell me, Joseph Neeb?
Yes.
Okay. All right. And Sherry Lippy?
Yes, that's my mother.
So, it's your mom? Okay. I would guess you were related because it's the same.
Yes, sir,
All right.
Your Honor.
All right. So no direct or indirect contact with either Sherry Lippy or Joseph Neeb.
Yes, sir.
Certainly left something out. Alcohol, weapons, firearms, contact. All right. Ms. Lippy, as I've explained, my role here, I've completed that. You are free to go do whatever you're gonna do as far as getting an injunction for protection from domestic violence. That's done at the courthouse. You can do that tomorrow. They will explain to you how that works. There may be some overlap between that civil injunction and the criminal conditions of release. They are two different and distinct things. They can talk to you about that injunction process, and that is a little more robust when it comes to how do you as parents of a child parent that child without having any contact. It's a trick.
It's hard.
It's difficult. It's very hard. But that will be more productive and more, as I said, robust than this restriction that I'm placing as a condition of release. Okay?
Yes, Your Honor.
I'm also going to appoint the Office of the Public Defender to represent Mr. Velosan. Mr. Boland, anything else before I conclude?
No, Your Honor.
All right, state anything I've overlooked?
No, Your Honor,
All right,
thank
Ms.
you.
Libby, thank you for coming in. You're free to go.
Yes, Your Honor, thank you.
Good to go? Okay, thank you, Your Honor.
I did. All right, the next one I have is Michael Eugene Fox. Mr. Fox, do we have, is this Mr. Fox Senior?
It is.
All right, Mr. Fox, do you promise to tell the truth, the whole truth, and nothing but the truth to help you?
I do.
All right. Okay, so Mr. Fox, you've sat through me saying this about 5 or 6 times now. You understand your role here. I'm gonna tender you to to Ms. Tyner, who represents the State Attorney's Office. She's gonna ask you some questions for our benefit. You may inquire.
Good morning.
Good morning.
What's your relationship to the other Mr. Fox?
I am his father.
And are you seeking contact with him today?
Sure. There was no abuse, no domestic violence, none of that.
Okay, and are you afraid of him?
No,
Has anything like this ever happened in the past?
no.
And if something like this were to happen again, would you be willing and able to call 911?
Of course.
Okay, no further questions at this time, Your Honor.
All right, Mr. Boland, any questions?
No, Your Honor.
Does Mr. Fox, the junior, qualify for a pretrial release?
Yes, Your Honor.
Okay. All right, I'm gonna find probable cause based upon the charging affidavit. I am going to release Mr. Fox, the junior, on pretrial release. All right, Mr. Fox, wait until I'm done, and we'll see if there's any questions that you've got. It's very important that you pay very close attention to what the rules of pretrial release are. You don't want to inadvertently, accidentally violate the rules. It's going to result in a revocation of your pretrial release. If when you are presented with those rules, you realize that that's more than you want, I'm going to give you the option of posting just a straight bond of $500 on the domestic violence battery and $100 on the tampering with a witness. I'm going to require that you have no hostile contact with your father, Michael Fox Sr. You can return to the home that you share on Cypress Preserve Parkway. I have jurisdiction over you to prevent you from having hostile contact with your father. I don't have jurisdiction over your father. So if he expresses to you by word or action that he feels that you're acting in a violent way, or it's your responsibility to retreat, not his responsibility to retreat. You understand that? I'm going to require you consume no alcohol or drugs, possess no firearms or weapons. I'm going to appoint the Office of the Public Defender to represent you, and I think that's going to take care of that. If you've got a question for me, you need to ask your lawyer first to see if it's something he can explain or someone from his office can explain down the road, or whether it's something you want to ask me while we're being recorded in front of the state attorney. You can ask your lawyer first.
Refuse the public defender, Your Honor.
I was representing myself today.
Okay. Do you want me to appoint the public defender, or you want to represent yourself?
I want to represent myself.
Okay. Let me spend a minute with you on that. You are entitled to represent yourself. Have you been to law school?
No, sir. I just have one statement that I need to make, and that's all I wanted to get on.
Before you make the statement, you've indicated you don't want a lawyer. You don't have to have a lawyer. You don't have to have an appointed lawyer, and you can hire your own lawyer, and you can represent yourself. I just have to advise you that you'd be at a disadvantage because Ms. Tyner has been to law school. She's passed the bar, and she's experienced in court. So should this end up in future proceedings, you're going to be at a disadvantage. You understand that, right?
Yes, sir. Once again, this is something that doesn't happen often between me and my father, so I definitely feel like we'll be able to work whatever.
All right. I'm gonna let you represent yourself. Is there anything you want me to know other than what you just said?
The only thing I wanted to make clear is that the issue we're having was just me moving out of the home, and I intend to move to Miami. So with pretrial release, I just wanted to make sure that I would be able to move to Miami because that was what my goal was.
Well, the reason I like to impose either pretrial release or a straight bond is when you talk to the pretrial release folks, if they tell you the rules won't let you do what you want to do, you can just post cash, post a bond, a monetary bond. Okay?
That's all.
All right.
Can I ask a question?
You sure can.
Is there any way that he can be released on his own recognizance or something like that besides the pretrial? Because we didn't have an interaction, physical or non-physical.
Okay.
I guess the police just did that, but I don't see any reason why he wouldn't be able to be released back to us. And me and his mom is just going to get together and give him his date that he needs to move to Miami.
All right. I'm comfortable with what I ordered earlier. I think pretrial release gives us a little more.
Okay, I'm not familiar with that. This is my first time in court, so you would have to explain to me what that is.
There's no money involved. Your son just needs to follow the rules, needs to check in with them periodically. They'll explain it to him, and if that's not going to work, then there's going to be some money. Not a lot of money, but some money.
Okay.
All right. All right, thank you, Mr. Fox.
All right, thank you.
Coming in. Have a good day.
You too.
Thank you as well, Mr. Fox. Next, I have James Joseph. All right, Mr. Joseph, do we have any witnesses on Mr. Joseph? No, Your Honor. Okay. Are we done with all the witnesses, or there's one more, or is that was the last one? All right, great. All right, Mr. Joseph is charged with battery by strangulation, domestic violence battery, and tampering with a witness to hinder communication. The victim appears to be Nesla Williams. Mr. Boland, any challenges for cause?
No, Your Honor.
All right, I'm going to find probable cause. I'm going to set bond in the amount of $1,000 on the battery by strangulation. And then 100 on the domestic violence battery and 100 on the interfere with tampering with witness to boy, I've been doing a lot of talking. Tampering with a witness to hinder communication to law enforcement. So that's going to be a total of $1,200. I'm going to require that Mr. Joseph have no contact directly or indirectly with Neela Williams, maintain separate residences, one trip back to collect personal effects in the presence of law enforcement, no alcohol or no drugs, no weapons or firearms, and I'm going to appoint the Office of the Public Defender to represent Mr. Joseph. All right, good luck, Mr. Joseph.
Cool.
All right, next I have Amira Benbow. Benbow. All right, so what I have with Ms. Benbow is I have an Orange County case. The charge is battery, domestic violence. The victim being Brunel Marseille. I find, having reviewed the charging affidavit, there's probable cause on that offense. I'm going to set bond in the amount of $500. I'm going to require that Ms. Benbow have no direct or indirect contact with Brunel Marseille. Maintain separate residences. No alcohol or drugs, no weapons or firearms. Return one time with law enforcement to collect personal effects. I also have an arrest affidavit for a violation of probation from Volusia County. That warrant serves as probable cause. It is a no bond, and so I'm going to stay the no bond for the for Ms. Benbow to be transported or to be received from Volusia County. And I'm also going to appoint the Office of the Public Defender to represent her on the Orange County case. I just jumped back. Sorry about that, Mr. Clerk, on the domestic violence case. All right, good luck. 500. Marquise Key. Mr. Key's charged with battery, domestic violence. I've reviewed the charging affidavit. I find probable cause. I'm going to set bond in the amount of $500.
Qualifies for PTR, Your Honor.
He does qualify for PTR?
Yes, Your Honor.
All right, I'll give him the option of PTR. No contact directly or indirectly with Shamada Dudley. Maintain separate residences. Return one time with law enforcement for personal effects. No alcohol or drugs. No weapons or firearms. Appoint the public defender. Brian King. All right, for Mr. King, I have two cases. One is domestic violence battery. I've reviewed the charging affidavit. I find probable cause. I'm going to set bond in the amount of $500. Require that the defendant have no contact directly or indirectly with his girlfriend. The victim wished to remain confidential. I believe her name is Jocelyn. She used to have no contact directly or indirectly with the victim. Maintain separate residences. Return one time with law enforcement to collect personal effects. No weapons or firearms. No alcohol or drugs. There's also a charge of driving a license suspended or revoked with knowledge. Failure to appear. There is a warrant for that failure to appear. There's a CAPIS, and that looks like that's out of Division 62. I don't know if this is a mistake. It indicates that the bond is $10,000. There might be some facts that I just don't know. I'm not going to interfere with Judge. That's going to be Brian Duckworth in Division 62. So I'm going to stay the bond, and he can take up with Judge Duckworth why the bond is so high for his failure to appear. And I'm gonna appoint the public defender on the new case. And if he doesn't already have one on the old case, I'll appoint, oh no, apparently he doesn't qualify. Let's see. Mr. King, your financial affidavit indicates that this is the amount of money you make every week. Is that right?
I make $1,000 a week. I work for Waste Management on Pine Hills.
Okay, all right. Based upon that, you don't qualify for the appointment of the public defender. So I'm not appointing the public defender. All right, Mr. King, good luck. Wilfredo Acosta. Good morning, good afternoon, Mr. Acosta. Mr. Acosta is charged with grand theft, 3rd degree. I've reviewed the charging affidavit.
I have a probable cause challenge, Your
All
Honor.
right, let me know.
The sale value is not the value that should be considered with a grand theft. They don't get, long story short, Judge, a retailer doesn't get the benefit of their sale, right? So they listed all of their prices. This is what we sell it for. That's fine. They don't get the windfall benefit of the sale when someone steals it. They get what it costs for them to put the item on the shelf. So everything that they listed on there doesn't amount to $750. It shouldn't be a grand theft case. So it'll be J08 if they charge it as a grand theft case. Simply not how you come up with the value amount when charging grand theft. And if that makes sense to Your Honor, that say I take something worth that they sell for $100, we all know that they're only paying $50 for it. They don't get the benefit of that.
I understood the argument, but the law enforcement has done the math, and the math comes to $794.90. So the question becomes, from the four corner, how do I determine what they're paying for it?
Because they said that it's the value of it. This is clearly what they've listed from their whatever sale value. They ran the receipt, they ran the barcode, and then they got the printout of this. This isn't the case where it's my personal computer where it has some value to it. This is, again, this is the retailer.
So what's the number if it's not $794.90?
There's no probable cause for it, Your Honor.
Okay.
As far as, I would say just based off the sheer number that they hit the highest level misdemeanor petty theft, and I know over 300 now. I would say just by virtue of the fact of the items listed that they can charge that, but I wouldn't say there's probable cause for a grand theft, just especially how close it is. The case law is clear. The calculation on grand theft is not supposed to be done based off the retail value.
Okay. All right. Ms. Tyner?
All I have to go off is the affidavit. The officers listed it as more than $700. While it may be difficult for our office to prove the value moving forward, as it stands right now, there is probable cause for grand theft.
Well, I think, Mr. Boland, you've got an outstanding argument for JOA or even a C4 motion, but for probable cause, I've been provided with a number of $794.90, maybe less than that. I just don't know how much less. So I'm going to deny your probable cause challenge. I am going to find probable cause. I'm going to stay the bond at $500, and I'm going to require that Mr. Acosta not return to the Harbor Freight Tool Store located at 7089 South Orange Blossom Trail. I'm also going to require that he have no contact with the co-defendant. I think there's a co-defendant in this case. It looks like Maurice Griffin. And also, he's to have no contact with the general manager of the store, Mr. Thomas Edward Romano. And I'm going to appoint the Office of the Public Defender to represent him. All right. Good luck, Mr. Costa. Next, I have, sorry. I have Andrew Chico. All right, I'm going to find that he's waived his appearance at the arraignment, at the initial appearance today. He's charged with petty theft with 2 prior convictions and retail theft. Any challenges for probable cause, Mr. Boland?
No, Judge.
Okay. I'm going to find probable cause based upon the charging affidavit. I'm going to set bond on the 2 prior convictions, petty theft in the amount of $500, and the petty theft retail in the amount of $250, for a total of $750. I'm going to appoint the Office of the Public Defender. Conditions of release are that he is he is not to return to the Walgreens located at 4502 South OBT, and he's not to have any contact with the representative of that store, Mr. Boycerand. And I'll appoint the Office of the Public Defender to represent him. He's also out on another petty theft charge, 2022 CF 8686 AO, which is in Division 15. He's out on a $250 bond on that. I'm going to revoke that bond, and he'll remain at bond on none until he sees the judge in Division 15. All right, next I have Ramius Davis. All right, Mr. Davis is here on a capias for failure to appear for a trial management conference for 4 counts, 3 counts of battery Leo, and 1 count of resisting an officer with violence. Based upon his failure to appear and that capias, I'm going to stay the bond at none until he sees the judge in Division 20 to discuss conditions of release. If he doesn't already have the Public Defender's Office, I'm going to appoint the Public Defender's Office to represent him. Maurice Griffin, didn't I already do? Didn't I already do Maurice? No, he's the co-defendant. All right. Mr. Boland, I'm going to assume you're going to make the same probable cause argument on the co-defendant?
Yes, Your Honor.
All right. I note your objection. There's no need to make it again. You made it very thoroughly the first time. I'm going to deny your probable cause objection. I'm going to likewise set bond in the amount of $500, find probable cause, no contact with the co-defendant, Mr. Acosta, no return to the Harbor Freight tool store located at 7089 South OBT, no contact with the store manager, Thomas Edward Romano, and appoint the Office of the Public Defender. The way I understand it is I'll appoint the PD, and then based on conflict, it'll go to RCC, or do I do that now?
No, we take care of that down.
Okay, all right, thank you, Mr. Boland. Richard Helmadollar. All right, Mr. Helmadollar is charged with fraudulent use of credit cards ×3, 2 counts of fraudulent use of credit card of greater than $100 and credit card theft. He's here pursuant to a warrant signed by Judge Kevin Weiss. I'm going to stay the bond as contained in the original warrant of $500 on each count for a total of $1,500. I'm required he have no contact with the victims, no return to the scene of the incident, and I'm going to appoint the Office of the Public Defender to represent Mr. Helmadollar. Cedric Jones. Okay, so he'll be reset within 24 hours of his return to the BRC from the outside medical. Stephen Rosado.
Yes, sir.
All right. Mr. Rosado here is on a possession of cocaine. I've reviewed the charging affidavit. I'm going to find probable cause. I'm going to stay the bond as indicated in the original charging affidavit at $1,000. Appoint the Office of the Public Defender.
Okay.
Next, I have Ramon Zarate Deju, charged with carrying a concealed firearm and possession of alcohol by a person under the age of 21. Any challenges, Mr. Boland?
No, Your Honor.
All right. I'm going to find probable cause. I'm gonna set bond on the concealed firearm charge of $1,000, possession of alcohol by a person under 21, $100. Those are the same amounts contained in the original charging affidavit. Conditions of release will be possess no weapons or firearms, consume no alcohol or drugs. The defendant also is out on bond of $2,500 on the same charge, carrying concealed firearm in Division 15. I'm going to revoke that bond, set bond at none. You can see the judge in Division 15.
Judge, did you set a bond for the DUI?
Sorry, that one's you, this one's me. All right. All right, Stephen Rosado.
Judge,
Ma'am.
did you set a bond for the DUI?
Oh, I just completely went over that.
Okay.
Thank you, thank you. We're not done yet. Mr. Zarate, thank you. Mr. Zarate is also charged with driving under the influence of alcohol or drugs to the extent his normal faculties are impaired. I've reviewed the charging affidavit. I'm gonna find probable cause. I'm gonna set bond in the amount of $500. I'm gonna require that, the defendant not consume any alcohol or drugs, nor is he to drive, without a valid license, and apparently he earns too much to qualify for the appointment of the public defender, so he's to retain his own counsel or represent himself. All right. Thanks for that catch. Appreciate it.
Welcome.
Stephen Rosado.
I don't have him on the docket, Your Honor.
He's not on the docket?
You have a,
We already saw him.
Did I already see him? I'm sorry. I thought his name sounded familiar. I already saw him. And then I snatched this back from Mr. Clerk. I apologize, Mr. Clerk. I got a little too fast is what happened. All right, next I have Jason Small. Jonathan Fort. All right, Mr. Fort is here on a charge of petty theft. A cell phone from Panino's Pizza. It's charged as a petty theft. I find probable cause. I'm going to set bond in the amount of $250. He does not appear to qualify for the appointment of the public defender. He is also out on bond in Division 17 in 2021 CF 14060AO.
To my understanding, Your Honor, that was diversion, and I believe that it's already completed.
Okay.
I'm gonna verify that right now.
Because it says return date TBD, that might indicate that. What I'll do is leave that alone, because if he's in diversion and this kicks him out of diversion, that'll be for Division 17. He also has a private counsel on that case, Mr. Yulo. If it doesn't, if he's already completed it, it's a nullity. So I think I'll just take no action, and that'll make it easier on all of us.
Your Honor, did you state the bond at $250?
I did.
Okay, thank you.
Andrew Gibson.
Hollis, you can get out today. Go post your bond.
All right, Mr. Gibson is charged with trespassing on a structure or conveyance. This is at the Wawa. Did Mr. Gibson want to consider resolving the case today? Sure. I took no action on his pending. Mr. Clerk, while Mr. Boland talks to his client, Do we know the status of this, the CF case? Can you look that up for me?
Your Honor, Mr. Gibson would like to accept the offer that was previously relayed by the state attorney, which was a withhold credit time served court cost.
Okay. Withhold. Court cost. I have the clerk checking. Apparently he's out on a felony. He's in pretrial diversion. Thank you. Will entry of plea to this, this charge of trespass affect his concealed weapon PTD?
Since he was picked up on a new charge, that in and of itself will affect it, but resolving this today, I don't believe should have any effect.
Okay. All right, is that all right with you?
Yeah, I explained everything.
Okay, all right, good deal. All right, and so Mr. Gibson?
Your Honor, I apologize. He would like to, he can go forward with the bond in this.
Okay, all right.
Okay.
All right, so I'm going to find probable cause on the trespassing and structure or conveyance. Does he qualify for PTR?
No, Your Honor.
Okay. All right, I'm gonna set bond in the amount of or stay the bond at $500 as in the charging affidavit. He does not appear to qualify for the appointment of the public defender. And conditions of his release will include a no return to the Wawa located at 3501 Millennia Boulevard.
You taking no action?
And I'm taking no action on the carrying concealed firearm for which I've been advised he's in pretrial diversion. So it's either gonna affect it or it's not, and he's either gonna be in it or he's not. Next, I have Joshua Jennings. Clinton McPhail. Mr. McPhail is charged with possession of less than 20 grams of cannabis. I find there's probable cause. I'm going to set bond in the amount of $250. And I'm going to appoint the Office of the Public Defender to represent him on this cannabis charge.
Your Honor, would the court consider, I don't think the state's even prosecuting these anymore. This looked like a frustrated officer.
Okay.
I'd be asking for the court to consider releasing him on his own recognizance. Clearly that officer was trying to paint him in a bad light, saying that he was a pimp of some sort. I would imagine a pimp would be able to bond out. He hasn't been able to post bond at this point in time.
Okay.
I mean, this officer, he charged him with weed because he was trying to get a charge to stick, so.
Okay.
The court can consider our.
Well, without responding to any of those assertions, I'm not agreeing or disagreeing with you, Mr. Bowen, on those.
Understood, Judge.
I do understand that the state is taking many different avenues to possession of cannabis charges, which don't include prosecution. Any objection to ROR on that?
No, Your Honor.
All right.
No.
Okay. I think we'll stick with no before, I'll move on before you change your mind. All right, I'm going to ROR Mr. McPhail. Mr. McPhail, this doesn't mean the case is going to go away. You're going to get court dates. You need to follow up with those court dates. I'm going to point the Office of the Public Defender to help you in that. But you're going to be released on your own recognizance.
Okay, thank you, sir.
You're very welcome. This guy already bonded. Gary Moody. Mr. Moody is charged with trespass on property after warning at the City View Apartments. Is Mr. Moody interested in resolving the case today?
I can confer briefly, Your Honor.
Sure. ROR.
Your Honor, I believe my conversations with Mr. Moody in the back, he's interested in the plea. He thinks the 7 days is a little steep. I think so too. I mean, where this location is, it's downtown. Was in the rain. He's offering the explanation that he got caught in the rain and was just trying to find an overhang. If the court would consider a lesser offer, if that changes the state's mind on anything.
Here's the concern I've got, Mr. Moody. If you want to resolve this today, I would accept a plea. I'd adjudicate you guilty of the trespass. I'd give you credit for the 2 days that you served in the Orange County Jail. In reading the charging affidavit, it says that you've been permanently trespassed from that place since this time last year. And that just the day before, the officer saw you at that area and there's a complaint about you being there. You understand you can't be there.
I understand that.
You gotta go somewhere, it's private property.
I understand that.
All right, so here's the deal. If I accept a plea, I'm gonna hear from, Ms. Tyner may have a position, I'm gonna hear from her. If I accept your plea and sentence you to something less than 7 days, the next time you come back, I might put you in jail for 30 days.
Yes, ma'am, that's fine.
Okay, because you can't be there.
I
understand that.
That'd
All
be
right.
fine.
All right.
If I would already knew before then, I wouldn't even been there then.
Okay.
I just don't remember Friday night because I was drunk. I'm gonna be honest with you.
All right.
And they asked me to leave, and I left.
Okay.
And yesterday was Saturday.
Okay.
And I'm being truthful. If I know I wasn't supposed to be there, I wouldn't have got out of drain there.
All right, Ms. Tyner?
I appreciate Mr. Moody's honesty, and I'm at the same position of the judge. I offered 7 days this time because you just got out on something else earlier this month. Please do not go back.
I'm trying my best.
If you see me again, I will offer 30 days, which is the maximum.
She'll do it too. She's very strict.
It's Sunday. I'm going to be nice. I appreciate your honesty. Maybe we can lay off the drinking a little bit and stay out of that area, and I'm fine with credit time served if that's the case.
All right. All right, Mr. Moody, understanding that, you want to go forward with your plea of no contest to this charge and get out today?
Yes, sir. Yes, ma'am, I do.
Okay.
But I want to go back to work tomorrow.
Okay, all right. Mr. Moody, you raise your right hand to be sworn. You promise to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right. All right, sir. You understand, I understand you want to resolve this case today by entering a plea of no contest. That means you're not agreeing that you're guilty of this, but you don't want to contest the accusation against you. Is that what you want to do?
Yes, ma'am.
All right. Has anybody pressured you or forced you against your will to enter this plea?
What do you mean?
Is anybody making you do this against your will, or are you doing it voluntarily?
No,
All
ma'am.
right. Are you under the influence currently of alcohol or drugs that may have affected your ability to understand what you and I are talking about?
No, ma'am.
All right. All right. And you understand that if you're not a U.S. citizen, entry of this plea could result in you being deported from the United States?
I understand.
Okay. All right, Mr. Moody, I'm going to accept your plea of no contest to the second-degree misdemeanor trespass after warning. I'm going to adjudicate you to be guilty of this offense. Court costs are mandatory. I'm going to reduce that to a civil judgment. I'm going to sentence you to 2 days in the Orange County Jail with credit for the 2 days that you've already served. That means you're going to go home today with the understanding that you are not to return to 595 West Church Street. No good comes of you going back there. You're not entitled to be there. Stay away from there, or next time the punishment's going to become greater.
Yes,
All right.
Yes, sir, whatever it is.
I've accepted your plea. I've imposed a sentence. If you think that sentence is illegal, you can appeal me. That appeal has to be in writing within 30 days. And if you need a lawyer to help you with that appeal, I can appoint one. All right?
Okay.
All right. Good luck, sir.
Thank you.
Larry Odoms. All right. Mr. Odoms is charged with trespass on property after warning.
We roll this, Your Honor. This is the same case. It's the one.
Yeah, looks like the same location. You want to have him come back tomorrow?
If there's a chance he could resolve.
All right. I agree. And have an extra day in. Dimitri Pierre. All right, Mr. Pierre is charged with petty theft and resisting an officer without violence. This is from a Walmart. All right, Mr. Bullen, any challenges?
No PC challenges, Your Honor.
Okay. All right, I'm gonna find probable cause. I'm gonna set bond on the retail theft in the amount of $100, and the resisting an officer without violence in the amount of $250. And I'm going to appoint the Office of the Public Defender. Should Mr. Pierre bond out, I'm gonna require that he not return to 1101 South Goldwyn Avenue, which is a Walmart. No good comes of that. And I'm going to appoint the Public Defender's Office.
Thank you, Your Honor. Yep.
Peter Roberts. All right, Mr. Roberts is charged with petty theft. Does Mr. Roberts maybe want to resolve this today?
What? Yes, sir.
Ms. Tyner, do you have a recommendation on sentence? Should Mr. Roberts want to resolve this today?
What's this? Just one moment, let me look over the criminal history. I'll defer to the bench, Your Honor.
Do we know if he has any prior petty thefts?
Two prior petty thefts that I see from, those two prior convictions for petty theft, and then, another arrest for petty theft. So yes, two prior petty thefts.
Okay. All right, Mr. Roberts, this is what I would do. If you want to resolve this today, you've got 2 days in jail right now. What I would do is accept your plea. I would adjudicate you guilty of petty theft. We're going to talk about that in a minute. I'd sentence you to 5 days in the Orange County Jail, which means you can do an extra 3 days.
Sure.
Court costs are going to be reduced to a civil judgment. And you don't have to do that. If you want, I'll talk to you about conditions of release. You could get out and come back another day and dispute this. You'd have a right to have a trial. You want to resolve it today? Okay, all right. All right, raise your right hand to be sworn, Mr. Peters. Mr. Roberts, do you promise to tell the truth, the whole truth, and nothing but the truth to help you?
Yes, sir.
All right. Tell me your name, please.
My name is Peter Jarrett Roberts.
All right. All right. Mr. Roberts, you're currently charged with petty theft. I've reviewed the charging affidavit. It appears though you're stealing food. Okay?
Kool-Aid, Starburst, Kool-Aid.
This is not your first petty theft. I'm willing to accept your plea. Before we go through that whole discussion with you, you understand that petty theft is a crime that they can add on top of. So each time you commit a petty theft, the penalties become greater. At a certain point, if you collect enough of these, the state attorney can choose to charge you with felony petty theft based upon these prior convictions, of which this is going to be one. What that can do is that can subject you up to 5 years in prison for felony petty theft. That's not going to happen today, but you need to understand that a consequence of your entering a plea to this today could result in a greater punishment should you go out and commit the same offense based upon these priors. All right? So if you feel as though you're going to maybe be in this situation again, facing a felony, and you don't want that to happen, you don't have to enter this plea. I'm not trying to discourage you from entering the plea and getting this case over with, but I'm not doing my job if I don't let you know that's a possibility.
Exactly.
Because then this happens, another judge says, well, you've charged with a felony, and you say, well, I was told that would never happen. You certainly can't say Judge Cameron told you that would never happen, because Judge Cameron told you that would happen. You understand?
Yes, sir.
All right, knowing that, based upon my explanation, you still want to go forward with this plea?
Yes, sir.
All right. Has anyone pressured you or made you do this against your will?
No, sir.
All right. Are you under the influence of alcohol or drugs so that you don't understand what's going on?
No, sir.
You understand that if you're not a U.S. citizen, you could be deported by entering this plea?
Yes, sir.
All right, and we just discussed this could be used against you in the future if you commit the same crime to increase the penalty and the punishment. You understand that?
Yes, sir.
Knowing all those things, you want to go forward with your plea, right?
Yes, sir.
Has anyone pressured you or, I've already gone through that. I hit myself coming the other way. All right. Mr. Roberts, I'm going to accept your plea to the charge of petty theft of first degree misdemeanor. I'm going to adjudicate you to be guilty. I'm going to sentence you to 5 days in the Orange County Jail. I'm going to credit you the 2 days that you've already served, so you have 3 more days before you get out. There's court costs, which I'm going to reduce to civil judgment. I'm also going to order that you not return to 938 West Colonial Drive, which is the
Family Dollar?
Family Dollar, all right? So you're going to become
Stranger to them.
you're going to become a customer of a different store, all right? All right.
Yes, sir.
All right, sir. You've entered a plea. I've accepted your plea. I've imposed a sentence. If you think that sentence is an illegal sentence, you can appeal me. If you want to appeal me, that appeal must be in writing. And if you need the assistance within 30 days, and if you need the assistance of a lawyer to handle that appeal for you, I can appoint one. All right? All right. Good luck, sir. Spencer Schubert.
Refuse, Your Honor.
All right. All right, Mr. Schubert's charged with petty theft from the Wawa on 12321 East Colonial. Apparently, he's been stealing the same pint of ice cream every day for $6.29. I'm going to find, based upon the charging affidavit, this probable cause. I'm going to set bond in the amount of $250. I'm going to find he's waived his appearance today. He's also apparently out on ROR on possession of meth with a return date for later this week. I'm not going to take any action on that because I'm not sure what's going on with that. So that will take care of that. Did you want me to consider appointing the public defender since he's not here to help him on that?
Please, Your Honor.
I'll appoint the public defender.
Thank you, Judge.
Sorry. William Stouffer.
He also refused, Your Honor.
All right, he's charged with possession of drug paraphernalia. Probable cause is found. Set bond in the amount of $250. Appoint the public defender. Find he's waived his appearance at initial appearance. James Wickman.
Yes, sir. Good morning, Your Honor.
Good morning. I'm well. Thank you, Mr. Wickman. All right. I have 3 things from Mr. Wickman. I have a trespass on property after warning, a violation of probation from another county.
Your Honor, with the violations of probation, I have it pulled up, the
Broward
sheet from Broward. I mean, I would ask that the judge didn't touch them regardless, just because it's a different county, let that judge figure it out, but it looks like he violated and then got time, did a sentence. 364 days with 270 days credit.
Yes, sir. I was released from jail about maybe almost 8 months ago. I terminated that sentence. I did a mitigated sentence. Anyways, I completed my sentence, Your Honor.
Is there a way to check?
I have it pulled up.
Yes, it's the paperwork.
Do you want to show that to the state?
Gabrielle Wheeler was my counsel. And I think I remember the state attorney's name also.
I mean, I trust that you know how to read.
2/12/21, scheduled termination
Do we
date
know
11/29.
what the location he was trespassed from was?
I have it right here. 12. You want me to tell him?
Is that a gas station?
It's a hotel.
Okay.
It was a civil situation.
You're good. That's all I needed.
Sure. Right there. Case number 10793 and then 10479. All right, so do you have the 107, both? All right, Ms. Tyner, what do you think about this? I have been provided proof that indicates Mr. Wickman has already completed those 2 probations. I can, on the outstanding warrants, I can ROR him with an explanation that Mr. Wickman better go to Broward County and sort this out, or the next time he's stopped by law enforcement, he's gonna get arrested again. Does that work for you?
That's fine with me. I saw the disposition. I understand that sometimes, I mean, I've had it happen to me before.
To you personally?
Not for violation of
You get picked up
probation.
on a warrant? Is that what
No,
happened?
no. But
Something
I
you need to
have,
talk about?
I have firsthand experience that sometimes court paperwork does not get
I understand.
done. So,
I understand. Did you have a recommendation on the trespass if Mr. Wickman wanted to resolve that one? Business
his
representative.
history, I don't think he has any prior trespass. He's been picked up for trespass several times, but he's never been convicted. So I can offer a withhold, court cost, credit time served, and a no return.
Do we know what 12350 East Colonial Drive?
I have it ready to pull up.
Sounds like
I
a
just
Wawa.
want to see. I think they said it was a hotel.
Do that if you want to fight it. But if you want to fight it, gotcha. So
It's a Hometown Suites.
Hometown Suites.
By Red Roof Inn. So we would just be asking for a no return to that location, credit time served, and court costs. A withhold as well.
it's like if you want me to fight it, we got to go downtown. If you want to get it resolved.
All right, so Mr. Wickman, let me take the easy ones first.
Sir.
You are here before me on 2 violation of probations out of Broward County. Your lawyer has done some great lawyering and pulled up those, and I've been provided with proof that those probations, as you've indicated to him, were terminated. So based upon that, I've got these warrants. What I'm going to do, they're no bond. I'm going to ROR, release you on your own recognizance. It doesn't make these 2 things go away. Your choice is to do nothing, or go to Broward County and get to the bottom of this and find out why they're arresting you on an outstanding warrant that shouldn't have been issued. The warrant, I believe, the warrant is outstanding, and my releasing you isn't going to make this go away. It's possible that if you get stopped by law enforcement, it's going to pop up again, and they're going to rearrest you on these. So it's in your best interest to get to the bottom of this and find out in Broward County. I don't have any authority over that. Only you have to go back to Broward County so you can figure out why there's a warrant, get those warrants recalled, do whatever it is you want to do. But I've been satisfied that there's nothing to hold you on since the cases are over. Okay?
Thank you, Your Honor.
You're welcome. Any questions you would have, I can't give you any advice, and mostly because for 2 reasons. I can't give you advice, and I don't know the answers. okay?
Yes, Your Honor.
So those are gonna go away. So I'm gonna release you under recognizance because I can't dismiss a warrant that I didn't issue.
Thank you, Your Honor.
You're very welcome. You've got this trespass. You've got the right to be presumed innocent of trespass. Your position could be, I want to come back, I want to have them prove that I was somewhere I was not authorized to be. You have a right to have a jury impaneled. The state has to call witnesses. You have a right to cross-examine those witnesses, call your own witnesses, testify on your own behalf, or remain silent. The burden is entirely the state's. If you want to resolve that case today, so what I'm gonna do is I'm gonna release you regardless to come back another day. If you don't want to come back another day, you can enter a plea of no contest to that. The state has indicated they wouldn't object to my giving you credit for the 2 days you served in jail, withholding conviction of guilt. It would appear on your record, but not as a conviction. There's mandatory court costs, and I'd give you a year to pay those court costs off.
What's the total of the court costs, Your Honor?
$223?
23?
No, that's a question. 273? $273, I'd give you up to a year to pay it off.
Your Honor, it appears Mr. Wickman would like to accept the court's offer.
Okay. All right. I don't know if I swore you, but why don't you raise your right hand? You promise to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
All right. Tell me your name, please.
James Hubbard Wickman, W-I-C-K-M-A-N.
All right. All right, Mr. Wickman, we've had a conversation about this charge that brought you to court today, or to jail today. Brought you to jail yesterday, which is a trespass on property after warning. It's alleged that you trespassed at 12350 East Colonial Drive, which appears to be a hometown suites. We just talked about your rights. You have a right to have a trial. You can come back another day. You can enter a plea of not guilty. Or if you want to resolve it today, you can enter a plea of no contest. I'll withhold conviction of guilt, impose court costs, and you'll be released today. Do you want to resolve it today by entering a plea of no contest?
It's your call. Situation.
I'd like to admit, Your Honor.
Okay. Has anyone pressured you, forced you into entering this plea?
No, Your Honor.
Are you under the influence of alcohol, drugs that may have impaired your ability to think clearly?
No, Your Honor, I'm not.
You understand that if you're not a U.S. citizen, you can be deported by entering this plea?
Yes, Your Honor.
All right. And you understand that if you are in fact on probation, which we've just, I think, determined that you're not, but you understand if you're on probation, this could be a new law violation which could violate your probation?
Yes, Your Honor.
All right. All right, sir. I'm going to accept your plea of no contest. I'm going to withhold conviction of guilt. I'm going to sentence you to 2 days in the Orange County Jail with credit for 2 days already served, so you're done with jail. Court costs are going to run you, I've been advised, $273. I'll give you up to a year to pay that off. Pay it off today. You can pay $27.30 every month for 10 months, however you want to do it. Just make sure you pay it off so it doesn't end up coming back on you and suspending your driving privilege or something, all right? You have 30, I've accepted your plea, I've imposed a sentence. If you think that's an illegal sentence, you can appeal me in writing within 30 days, and I can appoint a lawyer to handle that appeal if you can't afford one, all right? All right, good luck, sir. You're welcome.
I appreciate it.
Oh, yeah, and no return to the place that's on the thing, the place. Hometown Suites. All right, the next one I have is James Adams.
Yes, Your Honor.
All right. All right, well, we visited this yesterday. I think we found, is this the one with the challenge for attempted murder?
Yes, Your Honor.
Ms. Tyner, were you able to get any additional information?
I was not able to get any additional information. And because of that, we do understand if you would be amending the charge.
Okay. I'm not going to amend the charge as much as I'm going to find that there is probable cause that Mr. Adams committed the offense of aggravated battery. Let me not do this from memory.
Your Honor, Mr. Adams indicated that he can afford a $3,000 bond, considering that he would be able to pay a bondsman $300.
And then, Your Honor, I have the statute number for aggravated battery.
Okay.
It's Florida statute 784.045.
784.045?
Yes.
All right, so I'm going to find probable cause for aggravated battery with a deadly weapon.
And one final thing, Your Honor, related to his community ties, his entire family lives here, his children. He's.
Okay. Do you want to take some testimony? Why don't we go ahead and swear Mr. Adams? Mr. Adams, you promise to tell the truth, the whole truth, and nothing but the truth to help you?
Yes, Your Honor.
All right, Mr. Bowen, you may inquire of Mr. Adams.
Thank you, Your Honor. So, Mr. Adams, we're going to be talking about factors that the judge considers for terms of release, all right, but not the facts of your case. I don't want you to bring up the facts of your case at all, okay?
Yes, sir.
Okay. We talked about community ties earlier. You said you had family in the area?
Yes, sir.
Who exactly?
Your Honor, I have two sisters. They're older than me. They live here. I have a son and a daughter, 35 and 28 years old. I have 3 grandkids. A granddaughter that's 1. My 2 grandsons is 15 and 18. I have a host of nieces, nephews, and cousins that still live here in the Orlando area. I was born and raised here in Orlando, and I lived here all my life. I'm 57, and I work. I got my own apartment, and I just want to try to live my life.
And Mr. Adams, do you have any savings?
Yes, I got a checking account and everything.
Okay. How much would you be able to afford in bond?
I can afford at least $300, Your Honor, that I have in my checking account right now. But I don't have my wallet with me, but my sister does have my wallet, so
okay,
if it's possible, I can afford $300.
Nothing further, Your Honor.
Ms. Tyner, any questions of Mr. Adams?
No, Your Honor.
Do we know the condition of Mr. Jackson? Was he hospitalized or?
I believe he was taken, but I don't have any update on his current state.
Okay. All right, I'm gonna find probable cause for the charge of aggravated battery with a deadly weapon, that being a knife. That is pursuant to Florida statute 784.045. Mr. Adams, I want you to understand that where you find yourself is an initial proceeding. It's actually called an initial appearance, all right? So what that means is my job is to determine whether there's probable cause to believe a crime was committed, what crime was committed, and if you're the person that committed the crime. I'm relying upon a charging affidavit written by law enforcement that has some of that information. I've made a determination based upon that affidavit that the crime for which law enforcement arrested you, there's not sufficient facts to establish probable cause, which is a standard less than what the state would have to prove if you went to trial. They'd have to prove your guilt beyond and to the exclusion of all reasonable doubt. The reason I'm spending a couple moments with you on that is I don't charge cases. I don't work for the state attorney's office.
Yes.
I'm actually in a completely different branch of government. If you remember your high school or elementary school civics, there's 3 branches of government. The state attorney is the executive branch. I'm the judicial branch. I'm not trying to get too technical with you other than let you know that I'm making a determination of probable cause. Once the state attorney takes a hold of this, reviews it, examines it, turns it upside down, looks at it, they may charge you with nothing. They may increase the charge to attempted murder. They may decrease the charge. I don't have anything to do with that. So I want you to understand where you find yourself in this process, okay? All right, no worries. I don't want you to leave and think, okay, now I'm charged with this. You're not charged until the state attorney makes a charging decision.
I understand.
I don't even know what happened to the person they allege or accuse you of stabbing. That person dies, it'd be a different crime. Okay, all right. I've spent enough time on that. All right. So I'm making a finding of probable cause for that other charge. It's a lesser charge. It's still a very serious charge, and I'm gonna set bond in the amount of $5,000. And your lawyer has represented that you understand how bonds work and what you need to come up with, and that's not a concern I've got. I've got to impose a condition of release that both encourages or it creates more likelihood that you'll return for all court appearances, and also that you'll not be a danger to the community. Okay, all right. So I'm setting bond in the amount of $5,000. I'm also ordering that you have, that you not return to the location where this occurred, because no good comes of that. And that is the 7-Eleven mobile store at 2510 McGuire Road. You're also to have no contact directly or indirectly with Derek Douglas Jackson, the person that you're accused of stabbing. You're not to possess any weapons or firearms. You're not to consume any alcohol or drugs. I'm going to appoint the public defender's office to represent you, so they're going to help you going forward. Once you arrange your bond and get out, you can follow up with the public defender's office and then wait and see what happens. Okay? All right, Ms. Tyner, anything else I need to advise Mr. Adams of before I let him go?
No, Your Honor, thank you.
All right. Mr. Boland, anything else?
Nothing from the defense,
All
Your
right.
Honor.
All right. All right. Thank you.
Thank you, Your Honor.
All right. All right, next I have, and we're in the home stretch here. This is awesome. Stephen Haddon. Mental health, all right. So will he be reset then?
If we.
Or do we waive his
I have
appearance?
okay to plea on my,
I'm sorry, I did not hear you.
if we could roll this just because it's a pleable case.
Okay, all right. You might plead tomorrow. All right, let's just roll this to tomorrow and see if he's feeling better. All right, next I have Micah Nail. All right, Mr. Nail is charged with soliciting, Mr. Nail is charged with disorderly conduct. It appears to be taking something from an occupant of a motor vehicle. There's probable cause on that charge. He's also apparently out ROR'd on the charge of soliciting without a permit. Mr. Boland, have you discussed with Mr. Nail resolving both one or neither of these cases?
Briefly, I don't have an offer. There's credit time served across the board.
Yeah, he's already picked up on soliciting, but since this is disorderly conduct, I have no objection to a credit time served offer.
Okay. It looks like they've chosen a different way to charge him with the same behavior.
Yes, that appears to be the case. That being said, he got very lucky that it's charged differently.
Okay. All right, this is what I would do. If he wants to resolve both 2022 CO 951, which is soliciting without a permit, for which he's released on his own recognizance. I'm sorry? It hasn't been filed on? Oh, well, that's probably, well, I could take a plea to,
The county ordinance, I believe you could take.
yeah, because I'm about to take a plea to the city ordinance. What I would do is, he's got 2 days on the other, he's got 2 days on this. What I would do is I'd sentence him to 5 days for both, run concurrent. So he's gonna serve an extra 3 days, because he's got 2 cases. I would convert the court costs to a civil judgment.
Consider credit time served. If he doesn't take it, he's gonna wait here till 33 days.
Well, that's true. Mr. Nail, you understand you can't do this, right? I'm gonna explain to you what I explained to somebody earlier, and that is, I will take your lawyer's recommendation. He's being very persuasive today. I'll let you plead to both these charges. I'll sentence you to the 2 days you have on each. So you'll get out today. But what's going to happen is if you do this again, apparently you keep getting arrested. When you come back again, the state attorney is going to see that you just pled to 2 of these and you got another one, and she's going to want the judge that's sitting here to put you in jail for 30 days. So you just can't do this. Can't get caught doing this again. You understand?
Yes, sir.
So if I accept your pleas to this, can you assure me that we won't see you again?
Yes, sir, I can.
Okay, all right. All right, so you want to raise your hand to be sworn? You promise to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, tell me your name, please.
Micah Patrick Neal.
All right, Mr. Neal, you're here on 2 cases. One is 2022 CO951AO. The charge is soliciting without a permit. And then also 2022 MO 979AO, which is a violation of a city ordinance charged with disorderly conduct. The behavior is the same, which is what we affectionately refer to as panhandling. All right? You understand these are different cases. You go to trial on one, plead to the other, plead to both, go to trial on both. And that I would release you today regardless, but you'd have to come back another day to face these charges, or you can enter pleas of no contest to have them done. You understand that?
Yes, sir.
I understand that what you want to do is enter pleas to these and be done, so you don't have to come back to court.
Yes, sir.
All right. Has anyone pressured you or made you do that, make that decision against your will?
No.
Are you under the influence of alcohol or drugs?
No.
You understand that if you're not a U.S. citizen, you could be deported by entering this plea?
Yes.
And you also understand that if you enter these pleas and you come back again with the same charge, the state has the ability, there's nothing about your entering the plea, but we talked about the fact they're going to look at your criminal history and see that they've got to do something to stop you from doing it. And so they may increase the charges because you already entered pleas to these. You understand that?
Yes, sir.
All right, sir. I'm going to accept your pleas to both these charges. I'm going to adjudicate you guilty of, in 2022 CO 951AO, I'm going to adjudicate you guilty of soliciting without a permit. I'm going to sentence you to 2 days in Orange County Jail, credit you those 2 days, and reduce the court cost to a civil judgment. On 2022 MO 979AO, the charge of disorderly conduct, I'm going to accept your plea, adjudicate you guilty, sentence you to 2 days in Orange County Jail, give you credit for the 2 days you've already served, and then reduce your court costs to a civil judgment as well. I've accepted pleas to 2 cases. I've imposed sentences on 2 cases. If you feel those sentences are illegal, you can appeal me. Those appeals have to be in writing. And if you cannot afford an attorney for that appeal, that has to be filed within 30 days. I can appoint a lawyer. Do you understand all that?
Yes, sir.
All right, Mr. Nail. Good, Ms. Tyner?
I just want to say, I also have to deal with all the reckless driving. If what the judge has said today is not enough for you to not keep doing this, please know these people don't know how to drive and they're not looking for you. So your safety as well as your future depend on you not doing this anymore.
Yes.
That's right. All right. Thank you, Ms. Tyner. All right, I am out of paperwork. Are we done with the IAs?
We are.
Before 1:30? Unbelievable. If I hadn't talked so much, if I was Judge McGinnis, we would have been done 90 minutes ago.
I think his record's like 12:30.
Okay. He actually covered IAs for me one time because I have.
And Tressie Tyner for the state of Florida.
Okay. All right, so it looks as though Mr. Curtis is charged with trespass. There's probable cause. Is Mr. Curtis interested in resolving this case today?
Mr. Curtis, would you like to resolve your case today, or would you like to return?
Yes, I'd like to resolve.
You would like to resolve? Your Honor, Mr. Curtis would like to resolve.
All right. State if Mr. Curtis wants to resolve this trespass charge. It looks as though he was okay, so this was the one that he was in the looks like in a mobile home. I think he had a prior at the same place that he's out on ROR. This I may have spoken too soon. Maybe this isn't one that can be resolved today. Ms. Tyner, what do you think?
I can give an offer. I'm not sure if he'll like it.
Okay.
The offer I can give is going to be an adjudication, court costs, and 7 days in the Orange County Jail with a no return to the scene.
Can we resolve the other ones as CF? If I'm reading this correctly. Okay, so and someone feel free to correct me if I'm misinterpreting what I have in front of me. I have a charging affidavit showing a trespass after warning. The state's offer is a week in jail, I think because of the prior trespass. Is that right, Ms. Tyner?
Yes, Your Honor.
All right, and then I also have that Mr. Curtis is currently ROR on a felony. I'm going to guess maybe a felony petty theft. I don't know whether this will affect the, I wouldn't, if he wants to resolve the trespass today, I would leave the ROR on the CF alone and he could figure out what he's going to do with that. I don't know whether the trespass is going to have any impact on the case that he has, the felony that he has.
And Your Honor, may I have the felony case number?
Sure, and if you want to look that up and maybe pass the case, I have 2022 CF 8185.
22 CF 8185?
Correct.
One moment, Your Honor.
Sure. How many days, Madam Clerk, does Mr. Curtis have in? Or Mr. Officer Marino, do we know how many days he's got in on this trespass?
It appears he was picked up yesterday, Your Honor, so I would assume it's just one.
Well, yesterday if it's before midnight, you have 2 days in. And he was trespassed from the same location on the 24th. Okay.
Your Honor, I looked up the Orange County case, the felony, the CF 22 CF 8185. It looks like this case is unfiled, and that's why he was ROR'd on it.
Okay.
As far as his decision on the trespass, Mr. Curtis, what would you like to do?
I'll take the 7 days.
You'll take the 7 days? Okay, Your Honor, he advised he wants to resolve the trespass. Do I have him fill out a plea form, or is this just like a verbal resolution?
I think we can do a verbal plea.
Okay.
Has Mr. Curtis already been sworn?
No, Your Honor.
I want to go, why don't we, Mr. Curtis, raise your right hand to be sworn by my clerk, please.
Do you solemnly swear or affirm the testimony you're about to give is the whole truth, the whole truth, and nothing but the truth?
Yes, sir. Yes, Your Honor.
All right, tell me your name, please, sir.
Marlon J. Curtis.
All right, Mr. Curtis, you're currently charged with trespass after warning, which is a first-degree misdemeanor. I understand that you want to resolve this case today by entering a plea of no contest. No contest means you're not admitting guilt. You just feel that it's in your best interest to resolve the case today. Is that what you want to do?
Yes, Your Honor.
You understand that you have a right to be presumed innocent of this charge. If you wanted to, you could enter a plea of not guilty. It wouldn't affect your ability to get out of jail today, but you'd have to come back another day. The state would have the burden to prove your guilt beyond all reasonable doubt. You'd have an opportunity to confront witnesses against you, call your own witnesses, testify on your own behalf, or remain silent. And by entering this plea this morning, those are all rights that you're giving up. Do you understand that?
Yes, Your Honor.
Has anyone pressured you, forced you, made you do this against your will?
No, Your Honor.
Are you under the influence of alcohol or drugs that may have impaired your ability to think clearly?
I'm thinking very clearly.
Okay, good deal. All right, sir. I'm going to accept your plea of no contest to trespass after warning, a first-degree misdemeanor. I'm going to adjudicate you guilty of that offense. I'm going to impose a sentence of 7 days in the Orange County Jail. I'm going to give you credit for 2 days that you've already served, which means you're going to get out in 5 days. There are mandatory court costs. I'll give you up to a year to pay those court costs off. Your Honor,
one question regarding the county time. Because he's currently in Osceola for the trespass, the 5 days that he has left would be served in Osceola, correct? He wouldn't be transferred to Orange to do 5 days?
That is correct.
Okay, I just wanted to clarify the record.
Okay.
And Your Honor, the no return is, the address for that is 2540 North John Young Parkway.
All right. I'm also going to order that you not return to that location. No good comes of that, Mr. Curtis. They don't want you there. You're going to have to find somewhere else to go. All right, I've accepted your plea. I've imposed the sentence. Mr. Curtis, you have 30 days to appeal the sentence that I imposed. If you think that sentence is an illegal sentence, you can appeal me, but that appeal must be in writing. It has to be filed within 30 days, and if you cannot afford an attorney for that appeal, I can appoint one. Okay?
Yes, Your Honor.
All right, Mr. Curtis, good luck to you, sir.
All right, thank you.
And Your Honor, just to clarify, the ROR remains on the petty theft felony, correct?
It does. I'm going to take no action on that since
Did
it's
you
not
hear that, Mr.
filed.
Curtis?
Yeah, so,
Okay, so if that case gets filed, you have to return to court in Orange County, otherwise you get a warrant for a failure to appear.
But it,
You're still ROR'd on it because it's unfiled,
okay.
okay?
So technically, in the 5 days,
Yes, so just have a seat
I
and
don't
then,
have to worry about
for now, no, because it's unfiled,
Okay, thank
okay? Thank you, Your Honor. Have a seat, Mr. Curtis.
All right, thank you. All right, next I have Yenis Diaz de Mazar.
Your Honor, she requires a Spanish interpreter. Would Your Honor like to call her now or at the end of the docket?
Let's call the Spanish at the end of the docket, and then we'll have the interpreter for the beginning of the orange. So let's go ahead and pass Ms. Diaz. All right, next I have Dimitri Francois.
Francois is present and approaching.
All right, Mr. Francois is charged with battery and also resisting an arrest without violence. It appears as though the victim is his brother and the battery was spitting in his face. Based upon that and in review of the law, I understand also he resisted arrest without violence. I'm going to find probable cause. Do you want to be heard, Ms. Izquierdo, on release conditions?
Yes, Your Honor. Would the court consider Mr. Francois for PTR? I'm not sure if he qualifies because it's a domestic case in nature. Would the court consider a $100 bond on each count?
All right, so bond plus the PTR. Let's start with that. Mr. Marino, is Mr. Francois qualified for PTR?
No, Your Honor. He's currently out on bond in 22 CT 2446.
Okay, that's the DUI. All right. Ms. Tyner, anything you want me to know?
Yeah, since he already is out on bond, and he doesn't qualify for PTR, we would just ask that a reasonable bond be set and he have no contact with the victim.
It looks like Mr. Francois resides with his brother. All right, this is what I'm going to do. I'm going to take no action on the out on bond on the DUI. I'm going to leave that one alone. On this case, on the battery, I'm going to set bond in the amount of $500. On the resisting arrest without violence, I'm going to set bond in the amount of $100, so the total will be $600. I'm going to require that Mr. Francois have no hostile contact with his brother. Mr. Francois, what your contact is with your brother is whether it's hostile or not is in his eyes, not your eyes, okay? So if I'm going to permit you to go back to the house that you share, and you can have no hostile contact. If that's not going to work, you guys don't get along, and you realize that, you're going to want to leave that situation. You don't want more legal trouble. You've already got a pending DUI, and this case isn't going away. I'm going to require that you have no hostile contact, consume no alcohol or drugs, possess no weapons or firearms. And I'm going to appoint the Office of the Public Defender to represent you.
Thank you, Your Honor.
All right, good luck, Mr. Francois.
Thank you very much.
All right, next I have Sean Grew.
Present and approaching.
Hello, Your Honor.
Good morning, Mr. Grew. All right, I've reviewed the charging affidavit. I'm going to find probable cause. I'm going to set bond in the amount of $500. I'm going to require that Mr. Grew have no contact directly or indirectly with Christopher John Kennedy. I'm also going to, it does not appear as though they reside together. It looks like Mr. Grew went to Mr. Kennedy, so you're to have no contact. Mr. Kennedy, what that means is no.
Your Honor, I apologize, Mr. Grew.
I'm sorry.
Don't talk about the facts of your case.
My mistake. I'm sorry. I was looking at the.
Your Honor, Mr. Grew would like to clarify a fact with the court. I did advise him not to talk about the facts of the case.
Okay. All right, Mr. Grew, hang on one second. Let me explain to you that I'm reading a charging affidavit. It's a report written by the police. It contains a version of the events. It may not be the correct version, or it may not be the version that you agree with. I'm going to set bond. I'm going to require you have no contact with the alleged victim in this case. I'm going to require that you consume no alcohol or drugs, possess no weapons or firearms. Anything that you say can be used against you. We have a prosecutor in the courtroom right here. I would be surprised if there's anything that you say that's going to change what I'm going to do. However, I'm going to give you an opportunity to tell me what you want me to know, but I think it could make it worse for you. You may say something that you think helps you, but actually hurts you, that the prosecutor takes a note of, and may increase the charges against you, add charges to you, or maybe even persuade me not to release you under the conditions that I'm going to release you under. So I've told you what I'm going to do. You've expressed a desire to talk to me. You can do that. Your lawyer's suggesting you not say anything because it can't help, and she doesn't know what you're going to say. But it's up to you. If you want me to know something, that's good, but that's what I'm going to do, okay?
No, I'm good, sir.
Okay.
All right.
Yeah,
all right.
for the record, Mr. Grew qualifies for direct PTR.
All right, Mr. Grew, I'll give you a choice. You can either be released on pretrial release. There's going to be conditions, things you have to do, but there's not going to be any monetary connection. Or alternatively, you can post a bond of $500, and you just have to make sure you show up for any court appearances. Would you rather?
I'll take the PTR, sir.
All right, PTR it is. All right, so pretrial release. Make sure you know those conditions so you don't violate them. No contact directly or indirectly with the other gentleman, Mr. Kennedy. No alcohol, drugs, no weapons or firearms, and I'll appoint the public defender to represent you. All right, sir, good luck.
Thank you.
Thank you, Your Honor.
Next, I have Carlos Hernandez.
Mr. Hernandez is present and approaching.
All right. All right, I've reviewed the charging affidavit. Mr. Hernandez is charged with driving a license suspended or revoked, and also driving under the influence of alcohol or drugs to the extent his normal faculties were impaired. Having found probable cause, I'm going to set bond on each charge in the amount of $500. That's a total of $1,000. I'm going to require special conditions to consume no alcohol or drugs, and also not to drive unless lawfully licensed to do so. I'm going to appoint the Office of the Public Defender, and is he already out on something else? No. All right. That's all I've got. All right. Good luck. Good luck, Mr. Hernandez. Aaron Johnson.
Present and approaching.
All right. Good morning, Mr. Johnson.
Good morning.
All right, Mr. Johnson, I've reviewed the charging affidavit. It appears as though the victim in this case is your brother. I'm going to find probable cause to the offense of battery. I'm going to give you a choice of either pretrial release. Does he qualify? Does not qualify. Never.
Doesn't qualify.
Okay. I'm going to set bond in the amount of $500. Does Mr. Johnson and his brother live in the same, both live on Pickering? All right, you live separate? All right.
Yes, sir.
All right. All right. Mr. Johnson, I'm going to require, in addition to posting $500 bond, that you have no direct contact or indirect contact with your brothers. No need to talk to your brother directly or indirectly. No emails, text messages, IMs, anything like that. If your brother reaches out to you and wants to talk with you, that doesn't relieve you from the obligations that I've imposed, which is you're not to have any contact with him. I'm also going to appoint the Office of the Public Defender to represent you, and that will conclude Mr. Johnson. Thank you, sir. Good luck. Diamond Kimball.
President approaching.
All right, I've reviewed the charging affidavit. I find probable cause on the charge of battery. I wasn't able to tell from this charging affidavit, is this a DV case or a non-DV case? Does anyone know?
1 second here.
Sure. I'm also confused as to whether the other person was charged, because they have law enforcement identifies them as victim 1, suspect 1, and victim 2, suspect 2. Is Cameron Head being prosecuted? Was he arrested?
May defense be heard?
Sure.
As to probable cause, I did confer with Ms. Kimball. Ms. Kimball advised that the other individual is her child's father and that they reside together. In addition, on paragraph 2 of the police report, it states that allegedly a caller observed a black male and a black female arguing in the parking lot. The male proceeded to push the female, and they both began to push and pull each other near the vehicle. Therefore, defense would object to probable cause since it appears that the male was the initial aggressor and Ms. Kimball defended herself.
All right, State.
Yes, it's the state's position that based off the affidavit, there is probable cause. We understand there may be a defense for that charge, for the charge of battery based off self-defense, but the four corners of the affidavit do establish that there's enough for battery.
And also, Your Honor, I apologize for interrupting, but at the end of the page, it says that the suspect, victim 1, does not wish to prosecute. I believe that's regarding the male.
All right, do we know why they're listed as victim 1, suspect 1, victim 2, suspect 2? Is that just a style of drafting a charging affidavit because initially they didn't know who they were, or does anyone know, was Cameron charged?
Your Honor, defense believes it might be due to the fact that it's unknown whether, for example, on the second paragraph, it says that they both began to push each other. So I think at that time, perhaps the officer may not have been able to determine whether the male was a victim or a suspect, and the same thing for the female. And I think it was just entered as an abundance of caution.
All right. All right, well, the charging affidavit indicates that the independent witness observed them arguing, and that the defendant, Ms. Kimball, was not the aggressor. Then there was conversation. Then there's video. Where's the video? Bear with me 1 minute.
Second paragraph from the bottom.
All right.
On the
video surveillance. Seen walking toward the Nissan, approached the vehicle. Suspect 1 pushed suspect 2, who's the defendant, Ms. Kimball. Routinely and ordinarily, I would defer to the accusations based upon probable cause contained in the report. Oftentimes you've got an independent witness who sees something at the beginning, and there's video that maybe doesn't catch the whole thing, but both the testimony of the recitation of what's on the video and the testimony of what happened, what the independent witness observed, are consistent, and they don't indicate that the defendant was this defendant was the aggressor. I don't have a situation where we don't know what happened before the video started or before the witness started. It seems as though they are consistent that that's how it began. So I'm going to find there is no probable cause. I'm going to release Ms. Kimball on her own recognizance. Even though I'm finding no probable cause, I believe that since I'm RORing the defendant, I have the ability to impose the following restriction on her release. That is that she have no hostile contact with Cameron Head. Whether it's not in anybody's best interest. I don't know whether you all reside together. You could continue to reside together. You just don't want to have any hostile contact with one another. Ms. Kimball, if Mr. Head expresses to you he feels as though you're being hostile, even though you're not being hostile, you're going to want to remove yourself from the situation. You don't want the police to come and have them find that you violated the condition of your release. So just for review, no probable cause, ROR, no hostile contact. And did you want me to appoint the public defender?
Yes, Your Honor. She did submit a public defender application.
All right, public defender is appointed. Good luck, ma'am. All right, Luis Castillo, is that an interpreter case?
Yes, Your Honor.
Okay, we're going to pass Mr. Luis Castillo for a moment. Marley Normil Saint Two.
President approaching.
All right, I reviewed the charging affidavit. This charges reckless driving. I find this probable cause. I'm setting bond in the amount of $500. I will appoint the office of the public defender. Good luck. Next, I have Eduardo Rivera Benitez.
Spanish interpreter, Your Honor.
All righty. Next, I have Jorge Robles Nazario.
Spanish interpreter, and also the individual after him, Christian Sotolongo Zunica, also a Spanish interpreter.
All righty. All right. Then I have Reed Aquile.
President approaching, Your Honor. He is in the cage. Could you please give us a few moments to bring him over?
Absolutely.
Thank you.
Before I address Mr. Aquile's case, is he currently in custody on other matters?
Yes, Your Honor.
Okay, all right. All right, I've reviewed the charging affidavit. I'm going to find probable cause for the battery on a law enforcement officer. I'm going to set bond in the amount of $1,000. I'm going to require conditions, no contact directly or indirectly with Corrections Officer Diaz. I'm going to appoint the Office of the Public Defender to represent Mr. Aquile.
The Office of Public Defender to defend me.
Your Honor, he advised he does not want the public defender's office appointed.
Okay, then I won't do that.
Thank you.
All right, good luck, sir.
Thank you.
Have a seat, Mr. Aquile.
Alyssa Bird.
President approaching. Your Honor, Ms. Bird also has a pending felony case. I am the attorney of record on that case. That case is before Judge Karsten in Osceola County. Ms. Bird advised us she also wanted to resolve that case today. If Your Honor would entertain it, she did fill out a plea form. I have the case number. It is an adjudication credit time served. Aside from that felony case, she does have another pending case here in Osceola County that's currently unfiled. Would the court like to entertain that plea for the felony case, or would the court defer to Judge Karsten?
I'll defer to Judge Karsten. The only matter I have before me is the out-of-county warrant out of Lake County, and that bond is apparently none. So I'm going to find probable cause based upon that out-of-county warrant and stay the bond at none. So she may be able to resolve her pending Osceola case in front of Judge Karsten, and then I imagine that once that's done, she'll be able to be transported to Lake County. I don't know the different jails' policies. I know some counties won't let you out of their jail until they've resolved their case. So it might be she's got to resolve that in front of Judge Karsten before she can be transported or not. But that's out of my lane of travel and beyond my knowledge.
Thank you, Your Honor. I'll go
All right.
ahead and set her before Judge Carson.
All right, good luck, Ms. Bird. All right, so we have remaining the interpreter cases. Let me summon the interpreter. Is it possible when we're done with the Osceola interpreter cases to go into the Orange interpreter cases, or is that going to throw off the way you've got this organized? It's just another call. It doesn't matter to me.
In Spanish right after.
Right after? Okay. So we have uninterrupted use of the interpreter, and then they're done. All right, let me add a call to the interpreter. And do we have headsets down there, or are they going to hear through our?
No, Your Honor, they would hear from the screen. There is a large speaker over here.
Gotcha.
Good morning, Your Honor. This is Laura Bretaña, Spanish interpreter. The interpreter has not been sworn.
All right, Mr. Clerk, would you go ahead and swear the interpreter?
You raise your right hand. Swear or affirm today that you will translate from English to Spanish and Spanish to English the testimony given?
Yes, I do, to the best of my abilities. Laura Bretaña, certified Spanish interpreter.
All right, thank you. All right, the first case we have is Yenis Diaz de Villamizar. Ms. Diaz de Villamizar is charged with battery.
Señora, usted se le acusa de agresión física.
Sí.
Yes.
All right, I've reviewed the charging affidavit and find probable cause.
Habiendo repasado el documento acusatorio, determino que existen indicios de criminalidad.
Ms. Villamizar does not qualify for pretrial release.
La señora de Villamizar no cumple con los requisitos para el programa de libertad provisional.
I am going to set bond in the amount of $500.
Se concede fianza en la cantidad de $500.
I'm going to require that the defendant have no contact, direct or indirect, with Leonardo Villamizar.
Se le prohíbe todo tipo de contacto, ya bien sea directo o indirecto, con el señor Leonardo Villamizar.
They're to maintain separate residences.
Se les prohíbe la convivencia.
The defendant may return one time with law enforcement to collect personal items.
Se le permitirá regresar en una ocasión acompañada de las autoridades para recoger sus pertenencias.
No alcohol, drugs, weapons, or firearms.
Se le prohíbe la tenencia y consumo de alcohol, drogas y armas de fuego.
And I'll appoint the Office of the Public Defender.
Se designa la oficina del abogado de oficio para que la represente.
All right, good luck. Thank you.
Buena suerte.
That case number, Madam Interpreter, I just passed off. Do you have that case number, Mr. Clerk?
It's not have a case number, so I don't know.
Gotcha. Sorry, I have no case number for you, Madam Interpreter.
Okay, thank you, Your Honor.
All right, next I have Felix Lucas Castillo.
President approaching.
All right, Mr. Lucas Castillo is charged with driving under the influence.
Señor Lucas Castillo, a usted se le acusa de conducir bajo los efectos.
I find probable cause. I'm going to set bond in the amount of $500.
Determino que existen indicios de criminalidad. Se concede fianza por la cantidad de $500.
Special conditions are no alcohol or drugs and do not drive without a valid driver's license.
Las condiciones especiales de la fianza son: se le prohíbe el consumo de drogas y alcohol y también se le prohíbe conducir sin licencia válida.
And I'll appoint the public defender.
Se designa el abogado de oficio para que les represente.
All right, thank you, sir.
Gracias, señor.
Next, I have Eduardo Rivera Benitez.
President approaching. Your Honor, he did say good morning, however, I had him muted, I apologize.
Buenos dias, Mr. Rivera Benitez. Mr. Rivera Benitez is here on a Lake County warrant.
Señor, usted se encuentra aquí ante una orden de arresto del condado de Lake.
That warrant has bonds previously set.
En esta orden de arresto ya se habían establecido las fianzas.
Those bonds for the 5 charges total $42,000.
Las fianzas para los 5 cargos tienen un total de $42,000.
I do not have the authority to modify those bonds, and so the defendant will have to take that up with the judge in Lake County.
Yo no tengo la autoridad para modificar estas fianzas, así que el acusado tendrá que tratar esto directamente con el juez en el condado de Lake.
And if I didn't already say it, the out-of county warrant acts as probable cause.
Y si no lo había mencionado ya, en esta orden de arresto se establecieron que existían indicios de criminalidad.
All right, good luck, sir.
Buena suerte, señor.
All right, next I have Jorge Robles Nazario.
Present and approaching.
All right, Mr. Robles Nazario has 2 charges.
Señor, usted tiene 2 cargos.
One is domestic violent battery by strangulation.
El primero, agresión física, estrangulación por violencia doméstica.
I'm going to set bond in the amount of $1,000.
La fianza son $1,000.
I'm going to require that the defendant have no direct or indirect contact with the victim, Estefany Lorraine Centron Zayas.
Se le prohíbe todo tipo de contacto directo o indirecto con la víctima, Estefany Loren Cintrón Sayas.
They are to maintain separate residences, and the defendant may return one time with law enforcement to collect personal effects.
Se le prohíbe la convivencia y se le permitirá regresar en una ocasión acompañado de las autoridades para recoger sus pertenencias.
The defendant is also not to consume alcohol or drugs or possess weapons or firearms.
También se le prohíbe el consumo de drogas y alcohol y la tenencia de armas y armas de fuego.
Then on the other charge, which is failure to have a required endorsement on his driver's license.
El segundo cargo es no tener la debida autorización en su licencia de conducir.
I'm going to release him on his own recognizance.
En cuanto a este cargo, se concede caución juratoria.
I'm going to suggest that Mr. Robles Nazario obtain a proper endorsement prior to returning to court on that case.
Le sugiero al señor Torres Nazario que consiga la debida autorización en su licencia antes de que tenga que presentarse al juzgado en ese caso.
I'm going to appoint the public defender on the first charge, the battery by strangulation, but not on the second charge, the failure to have his vehicle properly endorsed.
Se designa el abogado de oficio en el primer caso, el de agresión física, estrangulamiento por violencia doméstica, pero no así en el segundo caso de no tener la debida autorización en la licencia de conducir.
All right, thank you, sir.
Gracias, señor.
Next, I have Christian Soto Longo Zuniga.
Present and approaching.
All right, I find probable cause on the charges contained in the charging affidavit.
Determino que existen indicios de criminalidad para las acusaciones que constan en el documento acusatorio.
On the charge of no valid driver's license, I'm going to stay the bond at $500.
En cuanto a la acusación de conducir sin licencia válida, la fianza permanece tal cual, $500.
On the charge of no motor vehicle registration and attaching registration not assigned, I'm going to set bond on each of those charges in the amount of $100.
En cuanto a la acusación de no tener la matriculación del vehículo y de utilizar una tablilla que no estaba designada a ese vehículo, se concede fianza por $100 en cada una de los cargos.
So the total bond will be $700.
Así que por lo tanto la fianza total es de $700.
Does Mr. Soto Longo Zuniga wish me to appoint the public defender on this criminal traffic charges?
Señor, ¿usted desea que se le designe el abogado de oficio en estos casos de tráfico?
Yes, Your Honor. He submitted an application, and also I see that there might be immigration consequences in this case. Just to be safe, the public defender should be appointed.
All right, I'm sorry, Madam Interpreter, I stepped on you. Go ahead.
Si su señoría, él llenó la solicitud, desea que se le designe el abogado de oficio, ya que parece ser que puedan haber consecuencias migratorias de esta acusación, así que para ir a la segura solicitamos que se designe el abogado de oficio.
All right, good luck, sir.
Buena suerte, señor.
All right, that's all I have for Osceola County. Madam Interpreter, we've got some Orange County cases we're ready to go into next. Let me just say goodbye to Ms. Izquierda first. Ms. Izquierda, anything else? Anything else from